Allow me to mention one matter for addition in the list as for restoration.
No, please excuse this one. It will not be possible.
My lord,
Contempt application may be listed, madam.
No inclusions,
under
please.
compelling circumstances are mentioned regarding SLST, Lordship may be pleased to recall this in review application. Your Lordship may be pleased to
Review application.
kindly appreciates, my lord. That circling issue that the candidates forgot to circle. If your Lordship kindly remembers, your Lordship dismissed the matter since I could not produce any evidence that the Commission has already allowed such kind of candidates. Even though they had not circled, Commission, considering it's a human error, has allowed. Since I could not produce any document before your Lordship dismissed it, rightly so. But now I have obtained the documents, my lord. It can be seen from the documents that Commission has allowed, despite there is no circling. Similar matter is, your Lordship is also hearing another matter on this point. My lord, the next interview list will be published. Verification today is mathematics verification.
But then I do
Let it
not
appear
think-
tomorrow. No, let it appear tomorrow.
And when the writ petition was filed, this document was not there.
Was not
This
there.
is something that you have discovered later on.
Yes, my lord.
And then you
Well, but-
filed application for review. It will
Yes,
take
I have
time.
filed. Yes, I have filed. My lord, I'm seeking leave to so let it appear tomorrow. That's all.
No,
Tomorrow is the application day, my lord.
doesn't matter. It cannot be done.
My lord, it was subsequently discovered, my lord. Your Lordship is aware of that issue, my lord. Kindly, my lord.
Yes, but then I don't think I'll.
No, kindly let it leave may be granted, my lord, so that it can appear tomorrow. Tomorrow is an application day.
You filed it.
No, they will not give me the number 48 hours.
For tomorrow, they'll not give the number. For next week, they'll give the number. You file it. Nothing can happen within a
The
day.
interview list will be
No, it
published.
cannot be done. Today you come up. Tomorrow it will be taken up. An interview list. You want your name to be there.
No, my
Sorry,
lord,
sir.
it
Please
was
file
not
it
our
in the-
mistake,
no,
my
sorry.
lord.
Yes.
Sir, kindly allows me.
No. File it in the department. Next week it will be seen.
Very good.
Pension for upgradation, interest and gratuity.
There are so many. Do not mention.
But wrong recording of the name of the advocates in Can 2, my lord,
Yes.
that matter.
My lord, the matter will be appear in the last month of November, but December month matter is not appeared to the merit list. Now inclusion on the list, my lord.
Nothing.
These four matters are in the monthly list. Praying for inclusion in the daily list.
Mother, I am paying leave to file and mother urgent writ petition challenging the 22 regarding mother, they are the untainted in-service candidate regarding the vacancy, 100% roster, and not only that, mother seat has been decreased, my lord. And
Seat has been.
decreased.
Which seat?
Mother, post the physical
Persian.
science, mother physical.
Persian.
Well, not only person, physical science, life science, my lord, home science, my lord. There are 5 subjects, my lord. At least 1,000 seats, my lord. Abolished, my lord.
If it is abolished, there are
They
no
cannot. I have
students.
challenged the rule. They cannot pursuant to the last order of the Honorable Supreme Court.
All right.
My lord, I am.
All right. Yes.
May I have your lordship kindly to mention
Is it affirmed?
No, my lord.
No, affirm. Without affirmation, it cannot be.
Upon, my lord, thereafter, my lord.
Thereafter, leave will be granted.
But I want to tomorrow or day after tomorrow. Otherwise, my lord.
Affirm the writ petition, sir.
Yeah, I
You affirm and come.
কে দিতে বললো লিভ দিয়ে
You affirm and give.
103 and 104 of today's list, my lord. The matter relates to, my lord, wrong question, and your lordship has decided that in the preliminary answer key they have given an answer I have correctly, but in the final answer key they have changed with 2 answer, but the preliminary answer is not there, my lord.
Alright.
Tomorrow is the date of
Where is the matter?
my lord. 103, 104 of today's
list.
today's
Tomorrow
list.
it will be upgraded.
Yes, my lord.
Your Lordship, may I have your Lordship's
Your other side should be intimated.
Yes, my lord, I will submit.
Yes.
Your Lordship, may I have your Lordship kindly to mention item of 249 of your Lordship's list. Your Lordship, I'm praying for upgradation. Your Lordship, in this, the managing committee has not been functioning for the last 20 months.
All right. Nothing doing today. Call the list, please. আপনি ডেকে যান আর অর্ডার আছে করে যান। হ্যাঁ, তো সেম অর্ডার করে দিলেই তো হয়ে যাবে।
But I am for the petitioner.
Who is your other side?
The page
2021 matter?
25. New motion, 7th.
Abhishek Kumar. This is the original side matter. Dismiss for default.
I am for the petitioner.
Mhm.
Page 34. The DI has granted
The management of schools for aided and
page 31. DI has granted the permission to the school authority for placement of their service of 7 assistant teachers.
Last week or five matters, same order.
Have been disposed of, similar order coming. 5টা ডিসপোজ অফ হয়ে গেছে
আমার একটু দেখানোর আছে।
আছে ও
Well, I appear for the state.
Yes.
this is the name.
Well, if one kindly takes this up, this from the DI.
রিপোর্ট
May I indicate the two paragraphs?
Yes.
The last two paragraphs, Millet. After perusal of materials on record, this office has queried the school authority regarding placement of departmental nominee, government nominee in the present ongoing management committee of the school, but the school authority did not answer satisfactory reply about the existence of government nominee in their present managing committee.
See, it says that the school authority did not submit any report. This is the last.
My lord, may I just explain this?
No, don't explain. If it is to be done, do it.
My lord,
formation of the managing committee.
can I just make
Please
the
come.
submission? Well, the DI is willing to do it, provided that there is a government nominee in the managing committee, my lord.
The petitioner
The
seeks
school has, well, the school,
approval of appointment in the Scottish Church Collegiate School stuff. It appears that the now from the communication, not communication, from the instruction forwarded by the District Inspector of Schools, Secondary Education, Kolkata, dated 1st December 2025, it appears that the DI is not in a position to proceed with the matter as the school authority did not submit any report to the office on the issue regarding placement of departmental nominee of the school and the date of hearing, nominee of the school in the ongoing managing committee of the school. Stuff paragraph. As it appears that the DI has already issued a prior permission for appointment. Accordingly, the DI ought to take all necessary steps to ensure that the process is concluded, that the process of appointment is concluded strictly in accordance with law. Stop. Did you serve the school? Is the school a party?
School party.
School is a party.
Other 5 matter. The school was served. Mr. Baid, engaged. The school instructed him not to appear since the school has done his job. School has already submitted the documents.
Acha. The school is not represented in court today. Stop. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Kolkata, to take all necessary steps for approval of appointment of the petitioner strictly in accordance with law. Step. In the event the school is not cooperating with the DI and is not furnishing the records sought for, it will be open for the DI to collect the required documents from the school authority. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Petition disposed.
Communicate.
আরেকটা line add up করে নিন।
It is also
It will
same.
be open for the DI to call for a hearing of all the parties prior to passing a final order in the matter if required.
Also same.
Is there any instruction?
Next matter তে আছে? Same.
তাহলে the earlier order will be there. যে অর্ডারটা দিল আগেরটাতে
The earlier order melody, there is no time limit.
time limit. I have mentioned here it's 12 weeks. এটাতে 12 weeks করে দেবেন তো দেখি কোন জায়গায় দেবেন? But will the date remain the same? Communication date
No,
at 20.
same. Everything same.
The fate of the approval shall be made known to the school and the petitioner positively within a period of 8 weeks from the date of communication. It is here, the date is here. Take it 12 weeks করে দিন।
I put the mention for correction. Advocate name was not incorporated there.
Oh.
Can
Whose name was not there?
advocate name
For which party?
for can 2. Indani Mujumdar.
Order date?
You don't. Name was.
Give the name. Yes.
On the last question, your lordship was pleased to give me direction whether to serve a copy of this learned advocate for the state council. Sir.
Learned advocate for the state.
I am from the state.
No, vocational council.
Vocational council, I am
Vocational.
that matter that earlier day your ladyship is to direct us to file affidavit and this is the
This is
order.
the order.
Yes, so
But here the question is that whether post is substantive or not, that has not been taken. Here the certificate, the headmaster only to that effect that they are working as a part-time teacher and they are a bona fide. This much.
Sir, will you-
but let him place.
Yes.
Let him
Well,
place.
kindly come to page 92. That is enough for
92.
92.
Yes.
This is a certificate issued by the headmaster. Kindly see, my lord. It is certified that
1 second.
8 petitioners,
8 petitioners,
all in different schools.
different schools. Different schools.
How many court fees have you paid?
8 feet.
Well,
One.
court fees had not yet been paid.
Substantive.
1 court fee.
1 court fee.
All right. Yes. Pay the rest.
Yes.
Yes.
And
Today,
then 92 is 1.
one kindly see the key, the certificate in the substantive post with
My lord.
effect from 6th.
Kindly see page 77 once.
That is mentioned there.
You are a teacher in English.
Yes.
Yeah. Till date in vocational department.
Kindly see page 89.
Yes, 18.
Yes. Page 92 thereafter.
Yes, ma'am.
একটাই গন্ডগোল আছে।
89.
89 is contractual teacher
No, not substantive.
or to the vocational stream.
First 77.
See, the headmaster mentioning substantive will not make much of a
Yes.
difference. It has to come from the DI.
Yes, yes.
So headmaster is in the school, you are teaching over there, he'll say you are the best person. But it cannot be helped. It has to come from the state authority. All right.
Well, the other matter is fixed on 23rd, I am told.
After exchange of affidavit.
After exchange of affidavit. Other certificates are
ওরা clarify
good.
করবে।
We can actually
Other
certificates, page 77, 8, 17 and all.
where
These
from
are-
are they coming?
Yes,
From the school.
77.
Part-time teacher or vocational.
Part-time, contractual, these are okay.
All are
They are
vocational
working
teachers.
with diligence, that might be.
No, it is not that vocational teachers will not be diligent. This cannot be said.
No, that is obvious. A certificate to that extent. 76, 77.
Same order can go down,
Yes.
Yes, yes.
right? You also come up with a report.
ওই অর্ডারটা
As
কোনটা
to-
দিয়েছিস?
ওই যে ওই order টা।
পরশুদিনের যেটা
হ্যাঁ, হ্যাঁ।
সেটা 23 তারিখে ফিক্সড হয়েছে এই অর্ডারটা হচ্ছে
The
কৌশিক রায়ের অর্ডারটা হচ্ছে
এখানে state বলাই আছে।
WPA নাম্বার 24884
Get from it.
Ah.
Get from it.
Services same, deficit court fees.
And court fees. Yes, yes. Court fees টা payment।
হ্যাঁ,
ফোরটা কি ফোরটা
আজকের
Please
মধ্যে
enter your appearances.
এই নাম্বার দে রে
Covered by your lordship's judgment, I applied as an SC candidate. My lord, thereafter I paid rupees 200. They accepted it, my lord. Thereafter, when the interview verification final list, I was put as a general candidate. Tomorrow is my verification, my lord. Kindly see first, come to my lord, page 42. Page 42. My lord, application fees, ST, SC, PH 200. The lordship has seen that. Now, my lord, registration status approved. 42, your lordship has seen that.
Yes.
Now, my lord, page 45, my lord, my receipt, online receipt of rupees 200.
Hmm.
And now, my lord, kindly come to page 50.
General female.
My lord, serial number 131.
Yes.
Lord, I'm fortunate well, my lord, of the order of
কোনটা এটা কোনটা
ওই প্রতিজ্ঞা থেকে দাঁড়িয়েছে
কি নাম কি মামলার
সোমনাথ প্রামাণিক।
this order
1 minute, 1 minute. What is this page 58? Amol Chandra Das.
My lord, this relates to my lord. After all this, they published a notification that because of pendency, we are going to you again submit your caste upgradation. My lord, this Amol Chandra Das matter relates to OBC. So I was of the impression that it only relates to OBC. That is why I did not act in terms of this.
insofar as the order that has been produced
Somnath Pramanik.
yes
Stayed by the appeal court.
no, the appeal is coming up today but it is there in the list.
Let it come. Please come. The petitioner participated in the recruitment process.
তোমরা প্রমাণিকের আপনি কপি দিস নি
Recruitment process conducted by the West Bengal Central School Service Commission for recruitment of assistant teachers in terms of the rules promulgated in 2025. Stop. The petitioner filed the application form disclosing her category as disclosing disclosing her reserved category. Stuff. She paid fees applicable in respect of the reserved category candidates, that is SC/ST/PH, rupees 200. Stuff. The name of the petitioner has been incorporated in the preliminary interview list under the category general. Stuff. The issue as to whether the commission could have suo motu changed the category of a candidate if the candidate did not edit/update his/her caste category in terms of the addendum notices issued by the commission has been decided by the court on 27th November 2025 in WPA such and such, name of the parties. কালকে একটা সেম অর্ডার দিলাম না তো সেমটা তাই করে দেবেন সেম অর্ডার করে দেবেন disposed. Yes, will be treated as general.
But since tomorrow is the interview, can I get a server copy by today?
আজকেই করে
I am for the respondent number 1 minute.
For the petitioner lordship, similar matter, scheduled caste candidate, I paid 200 rupees, my lord, fees, disclose my certificate. Later on, it was
show me please.
lordship, it's at page number 44, the application. Annexure P2.
And the preliminary list.
Lordship, the results, it's at page number 55. Wherein my written examination marks is 27. And the next page, my lord, its total marks is 37 and it's stated that not called for verification. And the very next page, 57 is the list.
But then the cutoff is 53. You got 37.
My lord, 36 is for scheduled caste candidates. Because I have been considered as general, it becomes 53.
No. No,
Yes.
please see page 44.
Yes.
Kindly sees his category. Yes, filled it as general.
Yes. You filled your category as general.
Lordship, at that point of time, because of the OBC matter, my lord, they were not
Are
taking
you
it.
an OBC candidate?
I'm not an OBC candidate, I'm scheduled caste candidate.
Then why you mention general?
My lord, they were not taking it as any category mentioned. And
No,
only
no, no,
when,
please.
because it was
Incorrect.
not being updated, that is why everything, my lord, by default, it was stated as general.
No. Then you cannot get the benefit.
And my lord,
You
he
have
paid, my lord,
disclosed your category as general and you pay 200 rupees.
my lord,
Very strange.
my lord, it was disclosed as scheduled caste.
Where is it?
My lord, but my lord, it was not taking in server at that point of time because of the
Yes.
So many matters are before your lordship.
because my lord, it was not taken, my lord, in that. I'll have the
Now,
next
this is
very
taking a
next matter.
calculated chance.
In the very next matter, my lord, similar matter is there.
Doesn't matter. There is an appeal pending. Let us see what happens.
That is in the very.
I'll post it next week.
Can you take the next matter? There is
Next, not this week. Only not this week.
tomorrow is the verification.
Then nothing can be done. You do not have a good case. See you next matter. Let me see.
Lord, in the next matter, my lordship will find similar matter, but there the category is not mentioned. Lordship kindly takes up the application.
This week, not this week. Page.
This is your item 6.
Page 44. Scheduled caste candidate 200 rupees, but here, my lord, the general, no category has been mentioned.
So you can, here at least you can get that. Do you have the certificate?
Lordship, it's not disclosed.
Where is it?
It's a page number 46.
46.
The category, the category picture. সেটা এসেছে সেটাতে পাস করবে ওই অর্ডারটা শুধু প্রামাণিকের অর্ডারটা পাস করবে
Very well. This can go down as the other one.
Yes.
Right? And it has been mentioned that the credential verification only after the certificate is produced, subject to checking up, verifying the credential certificate, then only the benefit can be given. Not that anybody can come and you'll treat the candidate as a SC, ST or OBC.
Very.
The earlier order will go down.
Lordship, but the last matter, Lordship, was that they have filled it up together. There was a discrepancy in the server itself. That is why they were not taking it.
Maybe. I do not dispute anything. But then since the other matter you see, nothing is mentioned, so I give you this benefit. That one I cannot.
So I can understand because in all the matters, nothing is mentioned. Only in this matter, I found that it is mentioned.
87.
I'm very, my lord, candid with the
Right,
court.
right.
Only this matter I found it. But Lordship, because the
Alright,
verification.
See what happens in the appeal court, then something can be done.
Then date may be fixed, my lord, someday.
Next week, next Monday it will appear.
Great.
Because the appeal is today. We'll
No, it is
tomorrow.
today. Hey, appeal কবে থাকবে?
7.
Affidavit of একটা দিয়ে না।
পরেরটা affidavit of service করে দেয়।
Affidavit of service.
But I'm appearing on behalf of the petitioner, my lord.
Yes.
This matter relating to, my lord, Group CD, the last date of online application is 3rd. My lord is well aware.
It has been
It's been extended possibly
It has been extended.
till
Extended.
till
Till 7.
8th.
8th.
My lord, I am praying for.
Has kept one matter on 8th.
Of Mr. Laidi's matter has been kept on 5th.
My lord, but this matter relating to, my lord, but
No, the
this
extension
candidate,
is till 8th.
Yes.
my lord, this matter
Yes.
relating to, my lord, all the candidates, they are waitlisted candidate in the 2016 selection process. Now, my lord, all the petitioners, they are age bar because they wants to fill up the form. They says you are not entitled to get the age relaxation. Kindly turn, my lord, page number 154.
Filling up the form, this process ended in June.
No. It's going on.
Oh, this is the
My lord, Group CD.
All right. I
That's
got mixed up.
that is
Sorry, I got mixed up. Yes, process is going on.
process
You
is
cannot
going on.
because you are age barred.
My lord, kindly turn page number 154.
154.
Why I before this court, my lord? I just
Yes.
annex one, my lord. The last portion, this roll number or name against it is not entitled for age relaxation. You should keep this field blank instead. So I am not getting the age relaxation. My lord, kindly take the apex court judgment. Kindly turn page number 125. The judgment start from page number 85.
Hmm.
Para 49. I read it. The disabled candidate mentioned in this previous paragraph will be allowed to participate in the fresh selection process, if required, with age relaxation and other concession. Similarly, that means in the same line, other candidates, not other employees or other teacher or non-teaching staff, other candidates who are not specifically tainted. So whosoever, so tainted candidate is two class. One is who are getting service and who are not getting service. Both are in the tainted category. Because my lord is well aware that Polas Noskor matter, my lord already passed order. So who are not specifically tainted? We are those candidates who are not specifically tainted, not get service. So we also entitled to age relaxation. Who are not specifically tainted will also be eligible to participate with appropriate age relaxation. In our opinion, such direction would be fair and just, as it would allow this candidate to take part in the fresh selection process, which should now be initiated to fill the vacancies. Very recently, my lord, Supreme Court in Vivek Paria matter passed the judgment, passed the order, my lord, in the same line. I just placed it, my lord, in Vivek Paria. That is 26th November 2025. I just placed it, my lord. The relevant paragraph, page 8 onwards, my lord. Page 7, last paragraph. We are informed that a writ petition being WPA number 26288/2025, that is Mosumi Mondal matter, today is in the list. I will place it accordingly at that time of when I will place that matter, my lord, has been entertained by a learned judge of the High Court at Calcutta, and various issues were flagged by the learned judge in her order dated such and such. 4 dates are mentioned, passed therein. The matter on the file of this court as on date were kept pending only for the purpose of verifying whether the direction of this court in the state of West Bengal versus Boishaki Bhattacharya Chatterjee and others were implemented scrupulously. As a learned judge of the Calcutta High Court has now taken up that issue also, we are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertake the exercise instead of this court. It would be open to all petitioner stroke applicants before this court to approach the High Court for redressal of their lawful grievance in accordance with law. The High Court shall, however, ensure that none of the tainted candidates are permitted to slip through in the press selection, be it on any pretext. The High Court shall also ensure that the listed of tainted candidate is placed in the public domain with full details so as to ensure that this does not happen. Learned counsel in some of the cases seek relief in terms of certain paragraphs of the decision in Boishaki Bhattacharya Supra. They are liberty to raise such hermeneutic exercise before the High Court. The special leave petition application disposed of in aforesaid terms. The next 2 paragraphs is very important. The High Court shall examine the matter uninfluenced by any of the observation on merits made by this court in the order passed after the decision of Boishaki Bhattacharya Chatterjee Supra. The High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit for the selection test to be held afresh, and their candidature, what is very important, candidature cannot be adversely affected by application of the new rules. That is the West Bengal School Service Commission selection for appointment to the post of assistant teacher for upper primary classes such and such, Rule 2025, pending application if any shall stand disposed of. So court intention is very clear. Whosoever not specifically tainted, they ought to give an opportunity, and the new rule must not be impediment for getting service. And I have, my lord, multiple prayer already, my lord.
Where is the rule? Show me.
My lord, I placed first. Rule is page number 63. My lord, before that, my lord, I placed the advertisement. Because why I placed advertisement, my lord? I will place because of that, my lord. I challenge the applicability of the new rule also, and in the line of the Supreme Court recent order, my lord.
Yes.
No, my lord. Advertisement is page number 79. Notification, and very important matter.
Yes.
First state level selection test 2025 for recruitment of non-teaching staff, clerk, group D in recognized government aided sponsored school in West Bengal. In compliance with, that is this advertisement in compliance with the order of the Honorable Supreme Court in Civil Appeal number 4800 of 2024 dated 3rd April 2025, which I placed just before it. The West Bengal School Service Commission is commencing selection process to the post of non-teaching staff in recognized government-aided sponsored school in West Bengal. Accordingly, this notification is being issued for conducting first state-level selection test. The selection to be post of non-teaching staff, such and such. I just now, Malad, this is the last line, which is contrary to the order. Accordingly, I just placed it again. Accordingly, this notification is being issued for conducting first state-level selection test for selection to the post of non-teaching staff in recognized government-aided /sponsored school in West Bengal against the vacancy to be received from the West Bengal Board of Secondary Education under the West Bengal School Service Commission selection of person for appointment to the post of non-teaching staff rules 2025. Earlier rule was 2009. That rule is also annexed to my writ petition, page number 135. This selection process will be governed by the West Bengal School Service Act 1997, subsequently amendment, NTS Rule 2025, and relevant state government guideline. Any citizen, that is the portion, I just skip it over. The age, page number 82. That is age. Eligibility. Para 7, page number 82. In clerk post and group D post, there are two type of posts. Last paragraph, last column, that is age limit. Minimum 18 years and maximum 40 years as on 1st January 2025. They make this age bar, but the Supreme Court intention is very clear. Whosoever the untainted candidate, they ought to give an age relaxation. They give an age relaxation to those candidates who got appointment. They not give age relaxation to those candidates who are waitlisted candidates, who are
There is a
untainted.
note just below.
Yes.
Age limit.
Yes.
Provided age relaxation will be given.
I will place it. I will place it. This says in accordance with the rules, in accordance with the judgment, but they not give it. Judgment is very clear. Judgment says whosoever untainted or not specifically tainted candidates, but they give it to the candidates who got appointment, not the others. Now, my lord, what is my prayer? In this context, judgment press this. My lord, prayer B is regarding age relaxation. 2005 rules, virus challenge is there, my lord. My lord, I want the applicability of 2009 rules, that is there in this the same Supreme Court line, my lord. I want, my lord, the list of all the tainted candidate and not specifically tainted. Why? Because I came under that category. That is not specifically tainted. That list is very required. Otherwise, my lord, who will get that age relaxation benefit? It is non-ascertainable. So that's why, my lord, I want two lists. One is tainted list, or another one is not specifically tainted list. Because in that category, two types of candidate will be there. One is that who got appointment, who not got appointment. So these two categories, my lord, is necessary. And in this line, my lord, already, my lord, passed in Polas Noskar matter, my lord, already passed the order, my lord. Tainted candidate list, my lord. And another thing, my lord, because in tainted category, my lord, I missed this on the last occasion, my lord. Another category ought to, my lord, inserted. Kindly turn page number 190. That category ought to inserted, my lord. Page number 119, that is, and board ought to make a party.
Yes.
Here board is party here. It is also important, para 37, my lord. It is also important to refer to another finding recorded in the impugned judgment regarding a discrepancy in the recommendation made by WBSSC and the number of appointment letter issued by the board. The investigation revealed the following disparities between the number of candidates recommended for appointment by WBSSC and the number of appointment letter issued by the board. So, number of appointment letter is higher than the number of recommended candidate in 4 category, my lord. It is mentioned how many excess number of appointment letter is issued by the board. The very next, my lord, very next page. When comforted, the board has proffered that all appointment letters were issued on the recommendation of WBSSC. Same thing had happened, my lord. Because of that, in that line, my lord, first CBI investigation was directed, my lord. On the other hand, the WBSSC contradicted the stance of the board by stating that they had not issued recommendation for the excess number mentioned by the board. So there is a conflict between two Article 12 authority. They ought to sit together, my lord. Who are the excess candidate, my lord? WBSSC and the board now claim that the discrepancy in the number of appointment letter issued is incorrect. The board counted all letters without adjusting for candidate who did not join, while WSSC excluded those candidates from its recommendation. Therefore, there is no discrepancy for teaching staff, and the small differences of non-teaching staff is irrelevant, as many of these candidates are already on the tainted list for rank jumping or being out of panel. We reject this late attempt by WBSSC and the board to reconcile the figure, as the number of recommendations made by WBSSC is independent of whether the candidate joined the post. So, my lord, that category also put in the tainted category list, because whosoever, because they have to tally it. There is apparent that excess appointments are there, my lord. It is evident from the chart itself. So, they ought to
And
even
is this for 9, 10, 11, 12, Group C, Group D, in
all categories? I will place in Mosumi Mondal matter, my lord, all category it happened. And not only that, in 9, 10 category, my lord, they just put 1,806 candidates. But if I go through, because Mosumi Mondal is also in my lord list, today's list, my lord, and in respect of Mosumi Mondal matter, my lord, the apex court passed this order, my lord, by mentioning that WPA number, my lord, that number also be higher. Because of that, my lord, this tabular chart, which is annexed in page number 113 in 9 category, my lord, just 19, I just, because my lord arose this question to me. My lord, kindly take page number 113 in 910 category. There are total rank jump and out of panel 185. Thereafter, my lord, 38. Got it, my lord? Combination of two. Thereafter, OMR sheet 952 and 907. কত আসছে দেখতো 2082 কত?
Yes.
185 plus 38 plus 952 plus 907. Most probably number 2082. So
Whatever.
they published 1806 candidate list. So that number ought to be the higher, because of they all are tainted candidates. Might be they not get the service, but they are the tainted category candidate, which is evident from this tabular chart, my lord. So whosoever in group CD, my lord, I place this matter. Whosoever the not specifically tainted is entitled for age relaxation. For the time being, as an interim measure, give that, my lord, age relaxation and give a chance to fill up the form, my lord, in the ensuing recruitment process, my lord.
Yes, Commissioner.
208.
There
Yes,
is
that number is 2082, my lord.
The rule is under challenge. I'll hear the state also. But then the interim relief regarding the age relaxation to candidates who appeared in the examination.
That perhaps has been decided in Arunima Pal's matter for 9, 10, 11, 12. Paragraph 30 of Arunima Pal's order,
What does it
age
say?
relaxation, is same points were urged. Kindly seize, Arunima Pal's.
Is it annexed?
No.
No.
Sir, if your lordship is having one of the compilations, either by the
You know what
commission or-
happens? The compilation goes with the file. So
My lord,
I can return it to you.
yes, no, that is
Because each and every matter this is being used
one compilation.
has to
Lord,
be kept over here separately. Yes.
the latest compilation filed by the commission, my lord, has all the documents.
Is this the one?
This is the one.
Right.
সেটা কোনটা এটা?
Second বলে যেতে
এটা?
যেটাতে 381 pages আছে।
হ্যাঁ।
The Arunima Palta কি তোমার
My lord, the Arunima Pal judgment of the division meaning 152, starting at 152.
Kindly seize paragraph 30 at internal page 18.
মাইকটা দিয়ে দাও, এই মাইকটা মাইকটা বিশুদ্ধ দিকে দিয়ে দাও।
Yes. Paragraph 30, you say? Is it paragraph 30?
30.
Yes.
Which portion?
To the candidates who have participated in the first SLST for classes 9, 10, 11.
I didn't get it.
The principal,
Principal issue.
the present, third line. The present appellants are waitlisted candidates. They were not given any appointment letter. In such, it has been seen, it has to be seen whether they at all have any right to challenge the present recruitment process. In our respectful reading of the concluding paragraph of judgment of Honorable Supreme Court encapsulated in paragraph such and such, certain benefits and concessions have been given to disabled candidates and candidates not specifically tainted. The disabled candidates were allowed to participate with appropriate age relaxation along with untainted candidates. These two categories of candidates could take part in the fresh selection with certain relaxation. Apart from
no,
the
no,
aforesaid
that's
two, no other category was specifically mentioned who would be entitled to any such relaxation or concessions in the fresh selection process to fill up vacancies. The appellants cannot be treated at par with disabled or untainted who were appointed but lost their job, as the entire selection process was vitiated by fraud. And in such background, in our respectful reading of the judgment of the Honorable Supreme Court, paragraph 49, age relaxation was allowed only to such categories of candidates who were appointed in the said selection process, who were appointed. The reliance on paragraph 5 of the miscellaneous filed before the Honorable, in our view, does not come to the aid of the present appellants, as they were not given any benefits of age relaxation and other concession. Admittedly, they were not appointed. The appellants, by reason of mere participation, do not acquire any vested right. It is mere exception that in the event all the posts are not filled up, or any vacancy arises due to failure of a successful candidate to join the post within a stipulated time, if they are waiting list candidates, they would be considered for filling up such vacant posts in terms of the merit list. Has raised another issue,
ওই ইস্যুটা এখানে নেই
Not required.
তারপরে প্যারা প্যারা 35 সেকেন্ড লাইন প্যারা 35 সেকেন্ড second sentence, I'm sorry. Para 35.
Please see. I will request your lordship to first see paragraph 32.
Yes.
The policy decision of the government is subjected to judicial scrutiny only in exceptional circumstances, where it appears that the policy or some clauses of the policy is manifestly arbitrary, discriminatory, malafide, unreasonable, or unfair, or if it is found to be against any statute or constitution, if it is dehones the provisions of the act or legislation, and if the delegate has acted in excess or beyond its power of delegation, such policy can be decided to be altered. The recruitment rules per se is not under here. These are different case, intelligible differential. And then, please see 35.
Page 25.
Page 25, internal.
Second sentence.
If the government felt the experience gained by candidates is relevant, the court cannot
This
take
is
a
the
different
experience.
No,
Correct.
next sentence.
Age.
sentence. Similarly, prescribing any age limit for a given post and also deciding the extent to which any relaxation can be given to the said age limit are essential matters of policy. So, read in conjunction with 33, 32, and with paragraph 30, I think
Compilation of 179.
no longer,
It paragraph.
no longer
Page 179 of the compilation is Supreme Court order
Lord,
upholding this.
Page 179 of the compilation, has not entertained the SLP from
Yes,
this
yes.
one.
I handed over that order, my lord. Orunima Swal SLP order, my lord. ওই তো দিয়েছি
179 of that compilation.
Is it the same date?
Yes,
Same.
21st.
No, no.
Yes, same date. 21st. It is there in the compilation. Is dismissed.
SLP having been dismissed, it presupposes that there is no merger, the bench's order remains. And therefore, it's a one-line dismissal. So, what I respectfully submit, that these issues are being once again re-agitated in a different dimension, so as to, set at not, or not to set at not, the judgment delivered by the Honorable Division. The endeavor should be to allow the process to.
এটা বলছে already tainted list এ আছে এটা তাহলে বিষয়টা তো বলতে হবে যখন sure
By raising issues, which have already been put to rest by a pronouncement of the division bench and which has been carried before the Honorable Supreme Court and which has not been interfered with, it presupposes that the issue is no longer available for judicial scrutiny, subject to correction by me. Those are my submissions. Prima facie, on the question of interim order. CD matter, the other issue is coming up on 5th. That is what I am told. I was not there yesterday. One matter was moved as to.
You were not there yesterday in all the orders. Your name is reflected.
I do not know why it is different.
Yes.
I was not there.
Who put in the slips? Please
I
inquire.
never inquired.
Because you should. You
No,
now henceforth you should. In all the matters, I saw your name, and I just wondered that I didn't see Mr. Bhattacharya today.
I was in fact,
Check up. I do not know. The orders must have been put in the server.
your lordship should not sign those orders. Remove my.
It has already been signed, and by this time it should be in the server, possibly.
mention
Right.
correction এর জন্য এটা আনে না
Because yes, because next time it will be mentioned that such and such person was not there, because today you are saying that I was not there.
And one matter, was sought to be moved. I know about the matter, it has.
Maybe.
Yes, but I was
Thing is-
officially not there.
See, to the court, it hardly matters.
Officially was not there. I am telling you a lot.
Yes.
But there's no dispute regard. I was not
And
there. Professionally, I was
It
not there
is,
yesterday.
it is not possible for a
100%.
judge to recollect who's there, who's not there. We see only the body of the order. There are so many corrections in the date, in the number and names and everything. But then whoever puts in the slip, ensure that only
Yes.
the counsels who are present, their names be put in. Otherwise, it's
It becomes embarrassing also for me.
একটা বলে দাও 37 এর নামগুলো আছে বলছে টেন্টেড লিস্টে নেম এন্ড রোল নাম্বার বোথ আর অলরেডি দেয়ার ইন দি টেন্টেড লিস্ট এই যে এই এক্সেস অ্যাপয়েন্টমেন্ট লেটার যেগুলো আছে না এগুলো নাম অলরেডি টেন্টেড লিস্টে পাবলিশ করা আছে নেম এন্ড রোল নাম্বার
But if your lordship also see 119 of their petition.
37 সুপ্রিম কোর্ট অর্ডার বৈশাখী অর্ডার
Court order,
yes,
where the
119.
yes, paragraph 37,
Yes,
the list, whatever, it also has the list of excess appointment letters.
yes.
করেছেন জজ সাহেব অনেকবার
That is also one aspect of the matter.
What aspect?
Wanted to raise, that.
additionally these names should be declared also published
So
That
this
these
is
names should
already a
also be
part
there.
of the
Tainted
already-
list.
it is already part of the
It's
tent
already a
is.
part.
name and roll number both those who were given excess appointment letter
It is being sought to be raised, every day, kindly visualize whatever orders are made by your lordship. Ordinarily, we are acting on them. Commission, in terms of your lordship's order, has also published a list, last week, indicating the father's name, the category, everything. It is not that we are trying to, avoid anything. Whatever is possible from us, of us, we are doing it to the best of our ability, So these things, these allegations, are perhaps, not correct.
All right.
Well, may I please?
1 minute. The state
We are not
will-
seeking to accommodate anyone. Let us be very clear on this, Mr. Bandopadhyay has made these submissions innumerable times. I think, every one of us who are appearing for the commission, we adopt that submission. We are not seeking to accommodate anyone. We are
Alright.
trying to do it at the best possible. There may be, certain areas which your lordship is correcting, and we are also seeking to, do it.
State.
Malad, in a nutshell, Malad, I've been able to push through my points through the voice of Mr. Bhattacharya when he was arguing, because he allowed me to assist him, Malad. So, Malad, as far as the other matter is concerned, Malad,
Matter means?
for the Polash Noshkor matter, after directing the list to be published
Yes.
with regard to Group C and Group D, your lordship has been pleased to keep the matter on 6th of January. Malad, your lordship in that Malad matter had been pleased to Malad observe that your lordship is not inclined to interfere with the process at this stage, Malad. Now, Malad, since the commission says that the list that they are concerned with today, Malad, is already published, your lordship will kindly restrict your lordship's directions, because
But then this is a different issue altogether. He wants age
Age-
relaxation.
for age relaxation, Malad, that submission has already been made by Mr. Bhattacharya,
Yes.
that in the interpretation of paragraph 49 of the Supreme Court judgment, who is supposed to get the age relaxation?
That is the commission's part.
They have
You are
coined.
the state and you are the rule making authority, right? So your rule is also under challenge.
Right. Malad, as far as the rule is concerned, the rule is, Malad, resonating the same age relaxation which has been granted by the Honorable Supreme Court in paragraph 49. Malad, what I am trying to impress upon your lordship is that this category or this class which is sought to be created, that untainted, unselected candidate, that was not the contemplation of the Supreme Court ever. The Supreme Court made it very clear that one is a tainted category and one is a not specifically tainted category.
By the way, 1 minute. Commission, why don't you publish a list where the
Tainted.
names of the untainted candidates are there? So that they get to know that, yes, I am not tainted.
Untainted selected candidates who lost their jobs in terms of the Supreme Court's order, untainted but selected. Who were working.
There is no other category.
There may
There is no other
be,
category.
there may be candidates who have not been selected, but they do not fall in the list of the tainted candidates. There may be candidates whose name fall in the tainted list, but they were not selected.
Then, perhaps, paragraph 30, perhaps your lordship
Has
does
to.
not deal with your lordship, perhaps, it was my incapability, please fall back to paragraph 30.
Arunima Paul.
Arunima Paul, that issue has been covered.
My lord, not covered. I will.
Get it.
Yes, my lord. Now, my lord, may I place, my lord, Mike,
Yes.
in reply, my lord. Kindly take Oronima's, my lord, division bench judgment, para 34, internal page 24. I not place the whole paragraph. Internal page 24, 1, 2, 3, 4, 5, 6th line. Got it, my lord?
Yes.
6th line. The recruitment rules 2025 has not been challenged by any of the appellant. So in Orunima Pal, in Orunima case, recruitment rules was not under challenge. Now, my lord, what is the recruitment rule? Kindly turn page number 74.
challenge.
74
Yes, my lord.
of your writ petition.
Yes, my lord, my repetition. The rules of CD 2025 rules.
Yes.
Page number 63, that is start of this rule. This rule may be called the West Bengal School Service Commission selection of person for appointment to the post of non-teaching staff rule 2025. This rule is under challenge in this writ petition in regard of age relaxation also. My lord, kindly turn page number 74. It is mentioned, first, my lord, the age is mentioned. Qualification. My lord, before that, page number 65. Rule 4. Qualification and age of the post.
Yes.
Qualification and age of the post. Subject to Rule 5, the qualification for the post shall be such as specified in column 3 of Schedule 1. 2. The age limit for the post shall, subject to provision of this sub-rule, be such as specified in column 4 of the Schedule 1. Upper age limit is, however, relaxable as per state government norms for scheduled caste, scheduled tribe, OBC, and physically handicapped candidate. Note 1. Age relaxation in connection with fresh selection process for recruitment of candidate to the post of non-teaching staff commences pursuant to the direction contained in the judgment and order of the Honorable Supreme Court in Civil Appeal number 4800 of 2024 dated 3rd April 2025 shall be given in accordance with the direction contained therein and to be passed in connection herewith from time to time. I want the equality, my lord. Now, note 2, age relaxation with regard to OBC candidate is subject to the orders passed by the Honorable Court from time to time. Now, kindly turn page number 74. What is Schedule 1?
Page number?
74.
70.
It is mentioned in Rule 4.
Yes,
It is
yes.
according to the schedule, my lord, last column, age limit. In serial number 2 and 3, that these two category, clerk and group D, minimum 18 years and maximum 40 years as on 1st January of the year of advertisement, relaxable by 5 years for scheduled caste and scheduled tribe candidate, 3 years for OBC and not subject matter of any litigation, 8 years for the physically handicapped candidate. Note, nota bene, NB. Age relaxation in connection with fresh selection process for recruitment of candidate for the post of non-teaching staff commences pursuant to the direction contained in the judgment and order of the Honorable Supreme Court in Civil Appeal number 4800 of 2024 dated 3rd April 2025 read with order dated 17th April 2025 in MA number such and such shall be given in accordance with the direction contained therein and to be passed in connection therewith from time to time. For consideration appearance such and such, I did not place it. Now, my lord, recently Vivek Paria, the last page. Because that Orunima matter went up to the Supreme Court. What Supreme Court observation in Vivek Paria to remanded back all the subject matter to this court, my lord. It is, I just read it again, the cost of repetition. The High Court shall examine the matter uninfluenced by any of the observation on merit made by this court in order passed after the decision in Boishaki Bhattacharya Chatterjee Supra. The High Court shall also be mindful of the fact that the untainted candidate in the first selection were allowed to sit for the selection test to be held afresh their candidature cannot be adversely affected by application of new rules. That is the West Bengal School Service Commission Selection for Appointment Rule 2025. So my case is that, my lord, in Orunimapal is a distinguishable case. In Orunimapal, the division bench observation was that there was no rule challenge. Here rule is under challenge. I want, my lord, equality. That being an untainted candidate, being a not specifically tainted candidate, because I am untainted, I could say so because I not get the service. Because being an untainted candidate, I am also eligible for age relaxation. The points of equality, my lord. My lord, this case, my lord, adjudicated as a fresh matter because of that, my lord. That is the Supreme Court, my lord, order, my lord. And not only that, my lord, I have another prayer is that, my lord, publication of tainted list and not specifically tainted list, and as well as, my lord, include all the categories, my lord, and mentioning the category. That is most important, my lord. Until and unless that is happened, my lord, we will not get the proper justice.
Did you find the name of any candidate whose name is there in the wait listing, in the wait list, included in the tainted category?
No, not yet, not yet, not yet. Because of that, they published in these two category list, as per my humble understanding, that, my lord, in 9, 10, 11, 12 category, they only published the tainted teacher list of 1,806 candidates.
Those
And
who were appointed.
those who are appointed. And in Group C and Group D category, 3,512 candidates. But actually, in Group C, Group D candidate, my lord, the last time I mentioned it, more than 7,300 candidates, my lord, they ought to put in the tainted category list because as per their list. And as well as in 9, 10 categories, that might be hiring up, that ought to be 2,082 candidates, and that would be more number because of that, my lord, this recommendation and appointment mismatch category. So only the Article 12, because it is evident from their affidavit, not from any others affidavit. Because of that, they themselves ascertain those candidates as a tainted one. This Article 12 authority, this I could say 3 Article 12 authority, that is SSC, West Bengal Board of Secondary Education, and CBI. These 3, my lord, list, my lord, if they compared with each other, then only, my lord, the proper tainted list will be ascertainable. Otherwise not, my lord. They ought to sit together, my lord. Until and unless they sit together, my lord, it is never be happened. The SSC by their own, they put the list. But this,
Please come.
May I only clarify 2 things, my lord.
Petition was carried, presented beyond on the 2nd of December 2020.
yes,
This written. This is both beyond the Honorable Supreme Court. Supreme Court never had, kindly pardon me for saying, the Honorable Supreme Court was not considering any wait-listed candidates,
they are uninfluenced, they say so. I challenge the rule.
by not interfering with Purnima, has put the question to rest. The matters which are Vivek Paria and whatever is being shown to your lordship is not at the instance of waitlisted candidates.
It might be.
Not at the instance, but that question perhaps is no longer open, subject to correction. Your lordship may record.
Muller, I wanted to, one factual aspect I wanted to clarify, Muller, at the cost of several repetitions, Muller. Orunima Pal had challenged the rules. Muller, we have given the writ petition without annexures in your lordship's compilation for your lordship's satisfaction at page 122. The rules were under challenge. We have shown to your lordship. So, Muller, factually, it is incorrect to say that the rules were not under challenge. Number 1. Other submission, Muller, we will make at the appropriate time in the appropriate matter. And the second question is that perhaps the endeavor of Mr. Bhattacharya to show Orunima Pal, no one is denying that last paragraph. But the endeavor to show Orunima Pal is that when the Honorable Supreme Court says that also to be mindful of the fact that the untainted candidate in the past selection process, it has to be read with that paragraph 30 of Orunima, that this untainted candidates means who were already appointed, not waitlisted, whose rights were not crystallized, as the division bench has held. That those who were not appointed, their rights had not crystallized into a vested right. No one verified waitlisted candidates ever. Neither CBI, nor commission, nor board. They were never under the scanner. So this terminology that they are coming up with, untainted, unsuccessful candidate, it was nowhere under consideration ever.
Which my learned friend, my lord, says so. My lord, I just given instances, my lord. Kindly turn page number 130.
No, the matter is likely to the division.
কালকে ছিল না যেটা
কত ভাই তোর সাথে কিছু কথা কালকে বলছে না।
my lord, kindly turn page number 113.
113.
For the cost of repetition, what my learned friend says, my lord, what would the meaning of that? My lord, kindly turn page number 113 in the cost of repetition, table 2, just table 2. My lord, in assistant teacher 910 category, total OMR mismatch is 952. Out of that, 808 candidate got appointment. So other remaining candidate, according to their submission, they are untainted because they not considered waitlisted candidate as per with the others who got appointment. So if their submission is sustainable, then as per the CBI list, whosoever the tainted not got appointment, they will not be treated as tainted.
So they are in the wait list. These 150 are in the wait list.
We are also 8 listed candidate.
There was
We
no,
were
there was no
equality.
scanning.
We
There
were
was no scanning with
equality.
regard to this.
That's my point. And we
Repeatedly
challenge the
reopening
rule.
same thing
We
which has
challenge
been
the rule.
Finally,
In earlier occasion, Aurunuma Palmeter, rule was not placed.
senior বলছে তো যে আপনি
এসব গোপা বুদ্ধি দেয় গোপার বুদ্ধি যাচ্ছে
How many petitioners are there? 14. Court fees?
already given Malad.
Check up, Vilesh.
Malad, I give it.
Uh,
If not given Malad, I give it here.
Yes. The petitioners claim to be the candidates who participated in the 2016 recruitment process for being appointed as non-teaching staff as clerk and group D.
পরেরটাও তো আনটি পরেরটা তোদের নয়
The petitioners were not successful in the said recruitment process. Stop. By virtue of the judgment passed by
আজকাল মামলাগুলো কি হবে
this court, duly affirmed by the Honorable Supreme Court
হ্যাঁ মাঝখানেগুলো কি আমাদের আছে
in
14 দিয়ে দিতে তাহলে ওই স্ট্যাটাস থেকে গেট কর ওইটাকে দেখিয়ে দিই ওটা
civil appeal arising out of SLP C number 9586 of 2024. State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and others. On 3rd April 2025. The entire selection process was nullified. Stop. The Honorable Supreme Court, however, made it clear that the candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation in the fresh selection process to be conducted by the Commission to fill up the vacancies. Stop. In compliance of the direction passed by the Honorable Supreme Court, comma, the West Bengal Central School Service Commission has initiated the recruitment process for filling up the vacancies of clerk and group D. Stop. The rules as per the rules in accordance with which the recruitment process is to be conducted was notified on 4th August 2025 in the Kolkata Gazette Extraordinary under the name and style of West Bengal School Service Commission bracket open selection of persons for appointment to the posts of non-teaching staff bracket close rules comma 2025. The age limit as prescribed in the said rules is minimum 18 years and maximum 40 years as on the 1st of January of the year of the advertisement, relaxable by 5 years for scheduled caste / scheduled tribe candidates, comma 3 years for other backward class candidates, and 8 years for the physically handicapped candidates. A note has been inserted in the rule mentioning that age relaxation in connection with fresh selection process for recruitment of candidates for the posts of non-teaching staff commenced pursuant to the directions contained in the judgment and order of the Honorable Supreme Court in Civil Appeal number 4800 of 2024, dated 3rd April 2025, read with the order dated 17th April 2025 in MA number 709 of 2025. Shall be given in accordance with the directions contained therein and to be passed in connection therewith from time to time. Stop. In line with the above rules, comma, a notification has been published by the Commission on 9th October 2025 for conducting the first state level selection test, 2025 for recruitment of non-teaching staff within bracket clerk and group D only bracket close in recognized government aided / sponsored schools in West Bengal. Stop. The opening paragraph of the said notification mentions about the order dated 3rd April 2025, passed by the Honorable Supreme Court in Civil Appeal number 4800 of 2024. The petitioners have crossed the maximum age as prescribed in the rules followed by the advertisement. Stop. According to the petitioners, comma, the age relaxation, na di hobe na, age relaxation, petitioners upor comma hobe. Age relaxation ought to be given to all the candidates who participated in the 2016 recruitment process, irrespective of the fact whether they were appointed or not. Stop. Submission of the petitioners is that the authority ought to have conducted the recruitment process strictly in terms of the judgment passed by the Honorable Supreme Court by providing the age relaxation. Stop. Not providing the age relaxation to the candidates who were not appointed in the recruitment process conducted in the year 2016 would adversely affect their rights. Stop. Next. The orders passed by the Honorable Supreme Court in the matter of Boishaki Bhattacharya within brackets Supra and the order dated 26th November 2025 passed by the Honorable Supreme Court in special leave petition within brackets civil diary number 46049/2025 Bibek Paria and others versus the state of West Bengal and others has been placed before this court to impress that the Honorable Supreme Court has directed the High Court to be mindful of the fact that the untainted candidates in the past selection were allowed to sit for the selection tests to be held afresh, and their candidature cannot be adversely affected by application of the new rules. It has also been brought to the notice of the court that in the same order, the Supreme Court recorded that the High Court shall ensure that the list of tainted candidates is placed in the public domain with full details so as to ensure that the same does not happen. Stop. The parties were given liberty to raise all issues before the High Court. Stop. The Honorable Supreme Court was also pleased to record that the High Court shall examine the matters uninfluenced by any of the observations on merits made by the court in the orders passed after the decisions in Boishaki Bhattacharya within bracket Chatterjee within bracket Supra. Stop. As an interim measure, it has been brought to the notice of the court that the last date for filing the forms in terms of the advertisement was 3rd December 2025, that is today, but the same has been extended till 8th December 2025. Stop. As an interim measure, prayer has been made to permit the petitioners to fill in their application forms subject to the result of the writ petition and to direct the Commission to publish the list of the tainted candidates with complete details, along with a separate list of candidates not specifically tainted, so that these candidates can participate in the recruitment process in accordance with the direction passed by the Honorable Supreme Court. Paragraph. The prayers made by the petitioners have been opposed by the learned counsels representing the state and the Commission. Stop. It has been submitted that whether the candidates who were not appointed in the 2016 recruitment process have a right to challenge the fresh recruitment rules has already been decided by the Honorable Division Bench of this court with a judgment dated 16th July 2025 in MAT 1017 of 2025, Can 1 of 2025, Orunima Paul and others versus State of West Bengal and others. In Orunima Paul within bracket Supra, the court was pleased to observe that the policy decision of the government is subjected to judicial scrutiny only in exceptional circumstances where it appears that the policy or some clauses in the policy is /r manifestly arbitrary, discriminatory, mala fide, unreasonable or unfair, or if it is found to be against any statute or constitution. the court specifically observed that prescribing age limit for a given post and also deciding the extent to which the relaxation can be given to the said age limit are essentially matters of policy. Stop. The constitutional courts in judicial review does not function as appellate authorities to examine the correctness, suitability, and appropriateness of a policy, nor full stop hobe na, nor they function as advisories to the executive on matters of policy which the executive is entitled to formulate. Stop. It has been pointed out that the special leave petition preferred against the judgment passed in the matter of Orunima Paul stood dismissed by the Honorable Supreme Court on 21st July 2025 in petition for special leave to appeal within brackets C number 19222/2025. Stop. It has been contended that the court in Orunima Paul clearly laid down that by mere participation quote that by mere participation a candidate does not acquire any vested right. According to the Honorable Division Bench, only the candidates disabled candidates and the candidates not specifically tainted were allowed age relaxation and could take part in the fresh selection process. Stop. Apart from the aforesaid two categories, no other category was specifically mentioned who would be entitled to such relaxation or concession in the fresh selection process to fill up the vacancies. Stop. It has been argued that once the issue has been set at rest by the court in the matter of Orunima Paul, within brackets Supra, the said issue ought not to be re-agitated all over again. Stop. Next. It has been submitted that the list of tainted candidates has already been published and steps are being taken to disclose the details of the said tainted candidates in terms of the order passed by the court. Stop. Paragraph. The matter is at a very preliminary stage. Stop. The for effective adjudication of the instant lists, comma, the parties ought to be given an opportunity to disclose their stand by way of an affidavit. Stop. The respondents may file their stand by way of a report supported by an affidavit. Stop. As an interim measure, now the court is only at this stage, Shuru Korun, at this stage, the court is considered. The court is considering as to whether any interim relief can be granted to the petitioners. Stop. The Honorable Supreme Court in Boishaki Bhattacharya within brackets Supra permitted the candidates not specifically tainted, permitted the candidates who participated in the 2016 recruitment process and who are not specifically tainted to be eligible to participate with appropriate age relaxation. Stop. It is an admitted fact that the Commission has not yet published any list of candidates not specifically tainted. The Honorable Division Bench in the matter of Arunima Pal also took note of the fact that it is the candidates not found to be specifically tainted who may be permitted to take part in the selection, in the fresh selection process with relaxation. Stop. In the absence of a list disclosing the names of candidates not specifically tainted, comma, the Commission possibly cannot restrict the age limit only to the candidates who have been found whose names do not appear in the list of tainted candidates published by the Commission. Stop. The candidates in the recruitment process of the year 2016 has now to be taken as two sets. One of the tainted ones whose candidature the Supreme Court has not approved of and has kept the tainted candidates specifically out of the selection process. And the rest, the untainted candidates, have been directed to participate in the recruitment process. Stop. The division bench in Arunima Pal was also of the same opinion that the untainted candidates be permitted to participate with age relaxation. Stop. It does not, none of the orders passed by the courts, either by the Honorable Supreme Court or the High Court, mention that the untainted candidates or the candidates not specifically tainted should be restricted only amongst the candidates who were given appointment. Stop. It may be the candidates who did not get appointment because the tainted candidates were put up in the list for the tainted candidates were provided appointment. Stop. Had the tainted candidates not been given appointment, many of the other candidates who are not specifically tainted could have got the job. Stop. The court, time and again, has reminded the Honorable Supreme Court, time and again, reminded that the High Court should be mindful of not allowing any of the tainted candidates to participate in the selection process. Stop. The same implies that any candidate who's not specifically tainted would be entitled to participate in the selection process. Stop. In view of the above, the court is of the prima facie opinion that at this stage, the commission ought to publish, not at this stage, the commission should immediately publish a list of candidates not specifically tainted so that they may take part in the fresh recruitment process if they choose to do so. Stop. The candidates who do not fall within the list, who do not fall in the list of tainted candidates, but are included in the list of the candidates not specifically tainted, be permitted to take part in the recruitment process with appropriate age relaxation. As the last date for filing the application form has been extended till 8th December 2025, the Commission shall take steps to publish the list prior thereto so as the candidates not specifically tainted can participate in the recruitment process with appropriate age relaxation. Stop. Let the matter appear in the list on 6th January 2026. When in January the other matter was fixed. 6th January? 6th January 2026. Prior thereto, the pleadings of the parties be concluded.
Just to
I am praying for stay of operation of the order.
Affidavit of service and court fees, and another thing is that Orunima Pal matter is regarding Group C 9-10 matter. This is Group C, Group D. Kindly note that. And another thing is that I want to cite just one judgment. Although it is in compilation, because of the third party can.
1 minute. Affidavit of service ke recorded রাখবেন. Deficit court fees, receipt দেওয়া আছে. This will be taken on record. Mr. Bandyopadhyay has prayed for stay. ওটাকে রাখুন. Yes.
Orunima Pal matter is regarding 9-10. This matter is a non-teaching Group C, Group D. Rule is separate. The challenge is by the separate
Principles are same. Principles of law are same.
আরেকটা paragraph add up করুন. Specific contention of the respondents is that the rule pursuant to which recruitment was being conducted for assistant teachers in classes 9 and 10 and 11 and 12 was under challenge in Orunima Paul within bracket Supra. ঠিক আছে? Be it recorded that in the instant case, the rule which is under challenge is the West Bengal School Service Commission bracket open selection of persons for appointment to the posts of non-teaching staff bracket close rules, 2025. And though it has been asserted by the respondents that that a similar rule was under challenge in the matter of Orunima Paul, but the court has noted that the Honorable Division Bench had specifically observed in more than one places that the rule is not under challenge per se, that the recruitment rules, 2025 per se is not under challenge. That's it.
Orunima Paul's rule is separate and this group CD rule is separate. And the states of candidates is also separate.
Anything else?
Well, since this, apropos to the last submission being made after the order, anyway, Malad, what my submission was that the principle of law will apply equally to both the cases, number one. And number two, Malad, I have also indicated from the compilation filed by the commission that the rules were in fact in challenge, Malad. That is at page 122 of the.
Mention that you assert that the rule is under challenge.
Yes.
The court has recorded that it is not under challenge.
Yes.
Now we go by the court's order.
Good.
Yes. And Mr. Bandopadhyay, after the order is dictated in open court, the commission prays for stay of the same stuff paragraph as the court has the court has considered such prayer and refusing to stay the order passed here and above. ঠিক আছে? পাঠাতে হবে।
But individual service and court fees
Yes, yes, that will be taken on record. এগুলোকে রাখবেন file.
Next matter.
Yes, next matter, please.
Next matter, affidavit of service and court fees kept on record.
In the next matter?
Yes.
Item 8.
8.
Yes.
But this matter is also group C, group D, but in the same line of Polash Noskor with an extra prayer. What is that extra prayer and why? Prayer, Polash Noskor I already handed over, my lord.
আচ্ছা এর আগেরটাতে বোধহয় পলাশ নস্করটা আছে, ওটা দিন তো, ওটা কাজে লাগেনি।
May I hand it over again?
ওটা কাজে লাগেনি। না মোটাটা না, একটা পাতলা অর্ডার, দুপাতার অর্ডার, ওটা না ওটা না ওটা না। হ্যাঁ 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 হ্যাঁ।
Polash Noskor আছে? But may
Yes.
This compilation also your lordship keeps with your lordship.
একটু এইখানটা
ওই কম্পাইলেশনটা দিয়ে দিন, 15 থেকে মামলা করতে লাগবে।
এটা এখানে থাকুক, পরে ওটাকে চেম্বারে পাঠাবেন। Yes.
My lord, in this line, my lord, I have a prayer. Although I challenge the rules in Polash Noskor matter also. In this matter also, my lord.
Is Polash Noskor pending?
Yes.
Yes, 6 January. 6 January.
6 January, yes, my lord. But because of that, my lord, this 10 marks argument is going on, my lord. In the same line, rule is challenged, 5 marks is also challenged, that is given for the experience marks. But in this matter, my lord, all the tainted list and untainted list is already Polash Noskor matter, my lord. Pass that order, my lord. But my lord, one thing is that is not yet, my lord, published by the West Bengal Central School Service Commission, that is counseling wise list in the 2016 selection process. Why it is required?
Not in the prayers.
There is specific prayer.
No, there is no interim prayer with regard to that.
Yes, but prayer H is that, my lord. My lord, why?
There is final relief.
Why
I'm sorry.
make my submission?
Yes, I'm sorry.
Sir? Why that is required? Because of that, my lord, in Vivek Paria matter, Supreme Court says not even a single tainted candidate slipped through the net, my lord. My lord, kindly turn page number 130.
Was Polash Noshkot challenged?
No, not yet, not yet. As per my information is subject to correction. Malad, kindly turn page number 130.
130?
Yes, Malad.
Yes.
There are four, one after another, that is Central, West Bengal Central School Service Commission, Malad, their chart, Malad.
Hmm.
From that chart, it is evident when the panel expired, Malad.
Hmm.
In four category, Group C, Group D, 9, 10, 11, 12. Some of the counseling, in case of just Malad, in the instance of 11, 12, that is 5,712 posts. Publication of final vacancy. Thereafter, date of publication of final panel 27th November 2017. Panel validity for 1 year, that is ended on 27th November 2018. Thereafter, my lord, kindly see the date of first counseling, 16/7/2018. Thereafter, second counseling.
All after the expiry of the panel.
Expect first and second. The third onwards.
Yes.
Third onwards, all are after expiry of the panel.
Yes, 19.
Yes.
All after.
And the very next page, same line. Very next page, Group C, Group D, in the same line. All after 2-3 counseling, my lord, all the counseling are after expiry of the panel. Now, my lord, I am placing the Supreme Court, my lord, judgment, my lord, para 30 and 31, which is annexed with my writ petition. Why I ask for this counseling wise list?
Page 130 is in respect of the Group C, Group D?
No, my lord. Page 130 is respect of 11, 12. Page 131.
This writ petition is about
Group C, Group D, at 132 and 133. I says it because of that combination. That judgment is combination of four
Yes,
selection
yes.
process. That's why I annex the four.
All right. But then 132 is Group C.
Yes, Group C, and 133 is a Group D.
All right.
So that's why I annex all these to showing that there is an expiry panel appointment, and Supreme Court take note of that, my lord.
All right.
I will place the Supreme Court judgment later on, my lord. So, my lord, in Group C, Group D also that is happened, my lord. So after panel, after expiry of the panel, there is an appointment, my lord. So they ought to publish the counseling wise list, my lord. Until and unless they publish the counseling wise list, how could because Supreme Court Vivek Parya matter is that might be in public domain. Until and unless it is in public domain, how could a candidate or any citizen ascertain who are that tainted candidate after expiry of the panel?
Want in this matter, you want the publication of
Counseling wise panel.
Counseling wise.
Because before that, my lord, I just want to canvas that Supreme Court judgment, page number 98. What was the Supreme Court observation regarding this expiry of panel? My lord, it start from judgment, start from
All right, page 98.
page 67, page 98.
Only one sentence I should say.
Who are you now?
Our Lordship is hearing the point of the expiry of panel.
Yes.
Now, this law point might get affected in the hearing which is continuing. All I say, Lordship may pass any order because Lordship is in the midst of it.
I make
Because paragraph 31 has been shown.
no, I am not 31. I am on 30.
Absolutely no difficulty. But all I request you, Lordship, that kindly hear us on the point of expiry of panel and thereafter. Because prior to that, my lord, any kind of, my lord, slightest comment, my lord, that.
See, this is what I was thinking, and I'm making myself clear so that they also get to know. There is an issue of stigmatization which was highlighted yesterday, that if the list of the tainted candidates is published, then these candidates get stigmatized. So why not publish the list of the candidates not specifically tainted? So at least for the time being, they can avoid the stigma.
But that's absolutely fine. I say different. List of the not specifically tainted, absolutely fine. list of even tainted, absolutely fine. But list of the persons who are not tainted, but might become tainted if Lordship holds that after expiry of panel, because they have been appointed, if that comes today, all I'm saying, kindly hold that part.
As of now, you are not in the tainted list.
I'm not in the tainted.
So if they publish a panel not specifically tainted, your name may go there.
There is no difficulty.
Thereafter, the court hears the matter and comes to a conclusion that the candidates who were given appointment after expiry of the panel will be treated as tainted. Then your name will automatically go out from the list of the not specifically tainted.
There is a likelihood that if Mr. Mitro does not begin, it will come today. I would be able to, my lord, 100% show and satisfy your lordship. Out of 8 counselings, all the 7 counselings, those were found by the CBI itself, yes, after expiry. That's why it is illegal, but not tainted because of XYZ reasons recognized by the Honorable Supreme Court. As and when it comes.
Yes.
Right.
But then your apprehension
Yes.
that if you fall,
Yes.
will be taken care of.
But so far as the list of untainted, no apprehension, no problem. So far as the list of tainted, no apprehension. Only apprehension is
Presently untainted, later tainted. That is the apprehension.
no. I would not even use that. List of candidates appointed, not tainted, but after expiry.
Yes, this the court has to decide whether it will be within the tainted list or not.
My response in one sentence: it has been
Decided.
decided.
Very well. The court will see.
That's what I'm saying.
You'll get a turn and
My lord, and now, my lord, I place the
Say that since lordship is hearing, ultimately it's everything is, my lord, interconnected. So maybe I was little excited only for this reason, because once lordship
I have followed.
Understand, it would be extremely difficult.
And I
for-
understand.
That-
I
that's-
understand your problem.
my lord,
Yes.
may I place? Because before that, my lord, because I'm learned senior friend, my lord, intervene in this matter.
No, it's
I just yes, I am not. I just say that I am not asking for that after expiry of panel. I am asking for the counseling wise that might be that they are absolutely fine, but I am not asking for the
absolutely fine.
yes. I for that is the reconcilement. I am not asking for any expiry of the panel. My prayer is very restricted that counseling wise list. That's my point. The court might hold that
No,
yes,
so what is your prayer right now? You want the list of the
counseling wise
panel as per the council.
counseling wise list. Because
Yes.
why I so kindly turn page number 98.
What is the primary challenge?
Primary challenge is rule, my lord. Rule 5 marks, 5 marks.
All right, that means the rules
that
itself.
means rules itself, my lord.
Right.
We call treatment and that tainted list as well as not specifically tainted
All
list,
right.
which is already covered by earlier order.
All right.
And
you participated in the earlier recruitment process.
yes.
And
I participate in this selection process also.
yes.
But
Here you participate.
I want to participate, my lord.
Want to participate.
Yes. I want to participate, and there is no relaxation is required, my lord. I want to
You are
participate.
within age.
Yes, my lord. And but I want- that's my prayer, my lord.
All
And but the counseling I want, my lord, the counseling wise list. And before that, kindly turn page number 98, my lord. Why I placed it, my lord. Page number 98, para 30.
But then, if the rule is under challenge and we can decide that, why is this list of counseling required immediately at this stage?
Counseling wise list, it be because of that, my lord. If my lord hold it, suppose my lord hold it, that there might be opportunity. 2 things might happen. One is that my lord might hold that yes, up to 8 round of counseling, everything is okay and fine. That is separate thing. If my lord hold it, that no, after 3rd round or after 4th round counseling, illegal or expiry of the panel, then my lord, that list is required.
All right.
So that purpose, my lord, that before expiry of the panel, decided this counseling wise list is required. That's my prayer, my lord. Because it will not harm anyone, my lord. It is a very innocuous one. Because of that, they already, my lord, hold it. They gave appointment, counseling wise they gave appointment, and they might publish it, my lord, counseling wise. And not only that, my lord, on instruction, although yesterday night, my lord, I searched it, I did not get it. By on instruction, I say so the board can appraise this court. After, at that point of time, up to second round of counseling, board in their website, West Bengal Board of Secondary Education, although yesterday night I gone through it, but I not get it. Up to second round of counseling, board in their official website uploaded whoever got appointment up to second round of counseling. Board in their official website, they published. But after second round of counseling, they never published it. That's my instruction, but it may be wrong. But yesterday night, I gone through the board's website, I not get it. Might be they withdrew it.
Yes.
Can I make my submission? Ma'am?
Yes, certainly.
Miller, kindly come to page 131, which he has cited. 130.
Yes, 130.
Very misleading statement is being made by the writ petitions. Page 130 is related to teaching and teaching stuff. I mean, class 9, 10, 11, 12. 131, 9, 10. Then 132. Group C. And Group C, kindly see, everything was done before expiration of the panel.
The last round is after expiry of the panel.
Wait, please wait.
You have said earlier after second round.
That is regarding 9.
After second round.
Yes.
Now, kindly see here, date of fourth counseling was 31st December 2018. Then number of vacancies, so and so. Status of panel expired on 18 May 2019. Then before that. Then next one, 133 also, Group D. Date of fourth counseling was 31st December 2018. Status expired on 4th May 2019. There were his statement in the submissions of that. Then that's all it. 130 is concerned. But that will deal with in the teaching staff matter.
Yes.
That there was a stay of operation of the order will deal with that. Therefore, whatever the submission is being made, that's totally to misguide this court, to mislead this honorable. There are number of matters it has been done. Anyway, now for the timing it is there. Now, secondly, Millard, what is his legal right to ask for all the types of counsel? One of the most unsuccessful person is disturbing the court, is disturbing us. That is also not appreciated. This time he has filled up. Anything is wrong, that's a different thing. But it cannot be opened like an ocean. Simply because 2025 rule has been challenged. 2016 you were asking, not asking. He didn't ask from the 2016 when the writ petitions have been moved, Group C, Group D. Everything, every prayer was there in the earlier petitions. I will show it to your lords, which has not been allowed. Now he is asking, he want to open like an ocean. Therefore, my lord, I will make a request that your lordships to kindly do not pass any interim order. My lord, your lordships have said regarding the tainted list of the tainted. We have published it. We have published it, and somewhere we are publishing. I've said. So far, the untainted is concerned. Also, my lord, we have, my lord, specifically untainted. It's a term is being used by the learned councils. Supreme Court has never said about specifically tainted or tainted. Supreme Court has untainted, untainted, and untainted is restricted to only the persons who are in the employment. All benefits should go to them, not to anybody else. Those who are in the waiting list, CBI has not made any inquiry. Then these are kindly direct the CBI who are in the waiting list, whether their candidate will come for tainted or untainted. CBI has restricted his investigation only to the persons who were in employment. CBI has not crossed the limit, and who are the unlisted, waiting listed candidates, no investigation was made on their case. That doesn't mean it should be treated that they are untainted.
My lord, if your lordship kindly comes to page 36. Page 36 for the writ petition, my lord.
Yes.
The prayer my learned friend is relying on, prayer H, is a final relief that he has claimed on the basis of pleadings, my lord, which your lordship may accept finally or not. If your lordship kindly takes prayers K, L, and M, my lord, none of these prayers are related to any category-wise publication of any list. My lord, the foundation of his prayer today is some people may have been engaged, appointed after the expiry of panel, as I have understood, my lord, because he may have made submissions, but I have not found any foundation in the first list, second list, first counseling, second counseling, etc. Ultimately, the buck stops that the panel expired on so and so date. Some people may have been appointed after that date. Your lordship has already pronounced an order, my lord, in Polash Noskor, that is WPA 22580. Polash Noskor, sorry. Polash Noskor WPA number is not, I'm sorry, 24996 of 2025. That is 1st December. Your lordship will kindly take paragraph 10 thereof. Your lordship has already directed the commission that as regards the candidates who were given appointment after expiry of the panel, their details shall be produced before this court on the returnable date.
But this is in respect of only 9 and 10, isn't it? 9, 10, 11, 12.
It is Group C, Group D. Kindly see
This is
paragraph
Group C.
1.
Oh, actually.
Group C, Group D, your lordship has
Right,
already
right.
directed the names to be produced before your lordship, my lord,
Alright.
those who were appointed after. Therefore, my lord, if his claim, my lord, as my learned senior, my lord, appearing for the commission already submits, my lord, if his claim is pertaining to people engaged after the expiry of panel, my lord, his cause of action was of 2018 and 2019. Therefore, his cause of action is not related to promulgation of the rules which is under challenge. The mere promulgation of the rules does not give someone a right to challenge it.
Just to indicate two things, my lord.
Yes.
My lord, kindly turn page number 132, my lord. What learned senior friend, my lord, says that none of the, in Group C, Group D category, none of the counseling is held after expiry of the panel. Entry 9, date of publication of final panel, 2012-2017. Panel expired on 2012-2018. Now, my lord,
18th May 2019.
Was it extended? Was the life of the panel extended?
Never be.
Because page 132, the second
Yes, entry, never be. It never, that's the was argument for the, and
Alright,
and in each and every column they say so, and that was not accepted by the apex court. That is para 30 and 31.
the petitioners participated in the
My lord, a new argument has been made. Kindly see the rule, earlier rule of 17, 2009.
the recruitment process for
My
appointment
lord,
as
my lord,
non-teaching staff. Stop. They challenge. They challenge the
my lord, kindly see the rules.
bracket
6
open
months time I was there in the to extend.
for appointment to the posts of non-teaching staff bracket close rules, comma 2025. Stop. The petitioners also pray for an interim order directing the commission to publish the list of the candidates called for counseling in the earlier selection process conducted by the commission in the year 2016. Stop. Paragraph. The matter will be decided upon exchange of affidavits. Stop. Released for further consideration on 14th January 2026. Stop. All pleadings must be concluded prior to the adjourned date. Stop. The interim order that the petitioner is praying is being refused at this stage.
Grateful, Malak.
Service is taken on record and the deficit court fee is also taken on record. Yes, next.
Lord, 9 I am for the petitioner, my lord.
Lord, E1909, I am for the state respondents led by Mr. Vaishak, who is in virtual mode.
My lord, this is my application for a direction upon the board, my lord, for changing my name to Jagannath to Shubhojit, my lord. On the last occasion, your lordship directed the board to file a report. Considering my gazette notification, my lord.
My report, your lordship. In copy, reported copy.
এটা ফেরত দিয়ে দিন।
কোর্টকে অত বড় দিন আমাদের এইটুকু
Yes. What
Oh,
does the
sorry,
report
report.
say?
My lord, kindly. May I? My lord, the petitioner, my lord, kindly may I read from paragraph number 3 of the report, your lordship. The petitioner registered himself as Jagannath Mitra with board and passed Madhyamik in 1994. Thereafter, my lord, senior secondary in 2012. Thereafter, he obtained some degree from the primary teaching institution and thereafter joined as a primary teacher in 2017. Now, my lord, passed Madhyamik in 1994 and he came up, he obtained all his service and all his certificates in the name of Jagannath Mitra. Now, in 2020, he made an application for change of name. Now, my lord, what I want to highlight before your lordship, my lord, paragraph 4. I state that petitioner declared his changed name as Shubhojit Mitra from Jagannath Mitra and got notified the same through the Gazette of India dated 2020. The said notification states that changed my name and shall hereafter be known as Shubhojit Mitra. That is in the Gazette notification, my lord, I have had it. So, hereafter, that is on and from 2020, January 2020, he will become Shubhojit Mitra. It has got no retrospective effect. When he registered, and your lordship, when he was born, his birth certificate, it is Jagannath Mitra.
Yes, yes.
Well,
it's all
my
right.
only contention, my only submission is with lordship that board is an authority who only holds examination, examination in the state of West Bengal. Board is not the authority to change the name or identity of any person. Well, it is only civil court, my lord.
Please wait.
My lord, this
Yes.
issue has come up before the Honorable Supreme Court in various high courts, my lord. There are at least half a dozen judgments.
Please show.
Yes, my lord.
What are the benefits that you want to obtain by changing your name?
Well, it is my fundamental right. If the changing of name is a fundamental right guaranteed under Article 19(1) and 21. So, my lord, this has been enunciated by Supreme Court also, various high courts also, and those were also the board denied, and there was direction. Specifically, if your lordship kindly comes to paragraph 171.
What you want? What is the benefit that you want to obtain? Are you retired or still in service?
In service, my lord.
You are still in service.
Still in service.
Oh, 46
Because the
years.
problem is this, my lord, I have changed all the PAN card, Aadhaar card, everything. From the next financial year, I cannot file the return also. My salary won't come. My salary would be coming in the old name, and my name has changed. Everything is there. So this is a predicament, my lord. For the
Creating my service file.
the service file is there, my lord. Everything has to be changed. So after Gazette notification, after the public documents, as per Evidence Act, my lord, your lordship knows that the presumptive value of those documents. On the basis of that, everything has been done. Now the board cannot say on this flimsy and these grounds, flimsy grounds that no, these are absolutely technical grounds they are saying.
No, my submission
And
is lordship.
exactly pat on the point, the judgments are there, my lord.
Madam, my submission
Lordship
is
kindly comes to
change.
What submission? Which paragraph?
Your lordship will kindly come to paragraph 171, my lord.
Judgmental copy দিলে lordship
Reported, right?
না দিলে কি করে বুঝবো? আপনি কি দেখাচ্ছেন আমি
171?
Yes, my lord. 2021 7 SCC. ওই 100 পাতা কি করে কত করবে? 2021 volume 7 SCC page 535.
বার কর না, কে বার 535?
Para 171. Jidya Jadhav versus CBSE.
বের কর, মাঝখানে দেখ। প্যারাগ্রাফ কত? প্যারাগ্রাফ কত বলবো?
171 বলে।
Which portion do you want to rely on?
Entire para 171 বলে।
171 is a big paragraph. You say which portion?
বার করে দিন।
There are two categories in
There are
171.
two categories. One is correction and second is changing of name. The second part, ma'am.
You want the second one,
Yes, ma'am.
right?
Yes, ma'am.
That means you acquire the name by choice.
Yes.
Right. In the latter category, it says
Yes.
that the request may be entertained upon insisting for prior permission,
Yes.
declaration by the court of law.
Yes.
The affidavit we have done.
No, that is
Affidavit is
That's the declaration, madam.
no.
Declaration before the first class.
Civil court. Before
Declaration.
civil court.
Are-
Obtain an order from civil court.
Fresh certificate in other situations.
Yes.
We have sweared an affidavit before the first class magistrate. That's a declaration, my lord.
No.
Thereafter, gazette notification.
Listen, had you not been in service,
Yes.
this would not have mattered. Since you are in service, all your service benefits are related to your name, to your identity.
Yes, madam.
And in the midst of the service career, you just think of changing your name. And without
That's
thinking,
subject to correction, madam. That's my right. I can change any time.
very well, you change your name, the court is not directing
No,
the
I'm-
authority. You change your name to whatever name you wish. It's your choice. It's your fundamental right.
Yes.
And the board is not there, or the Article 12 authorities are not there only to go on changing their records, only because you thought
lord-
of adopting a new name.
Madam, not on that. Madam, your lordship will kindly
Well,
come
you
to
have
the
to file
later portion of
declaration
171, madam.
and obtain an order from the civil court, and by that order, my lord, a direction upon the he has to get his birth certificate changed, and thereafter only board can change.
71,
171 lower portion.
I read it. I have expressed my mind as to how I read it.
Well,
Declaration by a court of law does not mean
Yes.
filing an affidavit.
Yes.
declaration subject to
When the
correction.
Declaration suit.
In an affidavit, you declare, yes, I such and such declare my father's name is such, my age is such, my address is such. This is not. Can that be treated to be a declaration? In that case, let the matter be heard.
Let it
the
be heard,
lordship
my lord. I shall produce all the judgments, my lord. I have at least 7-8 judgments, my lord. I will show before your lordship. And even in 2025, my lord, there is another judgment of the Jammu Kashmir High Court considering all these judgments.
Please show.
একটু judge সাহেবকে দিন।
You handed over the most voluminous one.
Yes, that's
জম্মু হাইকোর্টে কি বললেন?
হ্যাঁ বলে দিচ্ছি।
2025 SCC online.
Online JNK
JK
937.
67.
2025.
Which portion?
My lord, paragraph 14, paragraph 19. And if your lordship, my lord, if your lordship's desire is that we should have a proper declaration from the civil court, then your lordship will kindly grant us liberty so that we can get a declaration from the civil court and then approach.
হ্যাঁ, ওটাই তো, that is the procedure. Of an obtain civil court.
জজ সাহেব বললে নিশ্চয়ই যাবো, কেন যাবো না? সব পড়েছি।
লিবার্টির দরকার নেই, নিজেই করতে হবে, জাস্ট লিবার্টি দেওয়ার কি আছে?
আমি জজ সাহেবের লিবার্টি নিয়ে করি।
হ্যাঁ, ঠিক কথা। খুঁজে পেলি? এই জাজমেন্টটা দেখে আসবো পরের দিন। এসএসসি অনলাইন লিখেছিস? জীবনে খুঁজে পাবি না, এসএসসি অনলাইন লিখ। উফ, এখানে অনলাইনটা লিখ। আসবে না আমার, এতে গিয়ে দেখ, আমাদের indiakanun.com এর হোক, ঢুকে এটা মেরে দেখ আসছে কিনা। indiakanun.com থেকে মেয়ে হয়ে যাচ্ছে, মেয়ে থেকে ছেলে হয়ে যাচ্ছে, যা খুশি হলে।
HCC টা নিয়ে আসলে ভালো হতো, এটা লাইভ লটা চলে আসছে তো।
Question? এটা তো ছোট ছিল, এটা যেটা কত দিতে পারতেন আমাকে?
Paragraph 172, the Supreme Court exercised its plenary jurisdiction to pass this order.
But
So
then,
you have to keep this in mind.
but that has been followed by the High Courts, my lord.
Well, my only submission is, a lordship, I am not the competent authority to change the name or identity of a person, my lord. He has to, first, the lordship, admission in the register of the school and board has been done on basis of the
Check
birth
this order.
certificate.
Please
Lordship.
come. Report filed by the West Bengal Board. Report on affidavit filed by the West Bengal Board of Secondary Education in court today is taken on record.
এটা লিখে দিতে অর্ডারটা দেখে আসতে মামলা যাচ্ছে আবার ডেট দিচ্ছে।
The matter has to be decided. Stop. List on 9th January 2026. It will be open for the petitioner to file exception to the report prior to the adjourned date.
Right.
Take this back.
I'm grateful.
Jammu Kashmir, you've taken note of it?
Lordship, on 2025 SCC online. এই ওটা আমায় দিয়ে দিন না, জম্মু কাশ্মীর।
Of the other.
Yes, next.
কত 9 নাম দিয়েছে? হ্যাঁ নাম
I'm grateful, Lord.
থাকলো
নটা
নিয়ে নিল।
11. 11 or 10?
Your lordship,
10. Please come. 10.
This is in relation to Millard, a teacher Millard who was Millard convicted by a court of law, and Millard page 30 and 89. Your lordship's last order, Millard, your lordship was kind enough to direct the state authority Millard to file a report indicating that the admissible dues.
My lord,
As-
it's a report, my lord.
A given copy?
Yes, I'm serving, my lord.
Millard, my client,
To serve in advance, he doesn't get to know what is there in your report.
My lord,
What are you supporting the petitioner?
my lord, area claim, what is the grievance of the petitioner, my lord, already
Allowed?
come to the para 3, my lord.
Yes. Give a copy. Go through paragraph 3.
yes, Millard.
Timely submitted the area claim and already be dispersed in favor of the petitioner on,
2017.
yes, my lord. And the
Millard,
bill number is submitted in.
My instruction, Millard, I have, my junior had a talk with Millard, with the junior advocate record. She was instructed to submit that Millard, that is in her specific instruction, my client did not receive this benefit. And number one, even if Millard assuming not admitting that his statement is correct, Millard, the admissible due, Millard, it ended in the year to 2018. Millard, this was not admittedly released. And Provident Fund also, Millard, the government has no business to touch my Provident Fund unless, because your lordship knows section 60 creates a bar, Millard,
Paid
of the CBC.
suspension allowance.
My lord, let them take the instruction
You
from
did
the.
not paginate this. Please put a page number. I can see
Yes, my lord.
the
My lord,
paid suspension allowance to the headmaster. And is it by cash? ECS, it is. ECS payment.
Electronic.
Yes.
Yes,
it
my
must have-
client said, Millard, admitted due page 30 specifically states, Millard, till 2018. He worked.
Very
Number
well.
one.
This is
Twen-
only the suspension allowance till 17.
Yes,
For certain period till 17.
my client's instruction to the advocate on record, Millard,
Oh, not even till 17. It is from 1st June 2012 till 5th of July 2014, paid in 17. So not the whole thing.
not the.
What
whole-
about the rest?
কথাটা শোনো বল।
my lord,
Are there other bills also? After 14, did you pay anything?
my lord, kindly take the instruction, they kindly take the instruction from their client, my lord.
Okay, R1 says 16/2012 to 26/2012, 24/18, 2012 to 5/7, 2014. It comes around 2,43,157. And Millard, the next page also says, Millard, that is corroborated part 2. It says, Millard, ECS 2017, 2017, 2017. This is possibly the date of payment. this is also corroborated, my lord, 2,43,187. So this is, my lord, is corroborated by the previous one. So I think, my lord, my learned friend, esteemed friend should take instruction because it is an incomplete one, my lord.
My lord, kindly take me
Government
on
has
the
always, my
instruction,
lord,
my lord.
taken this matter very serious, casually.
Senior, my lord,
Detailed report, my
English,
lord.
my lord. Uh,
Listen, your senior will not be able to improve the position. The documents that you have annexed goes to show that subsistence allowance has been paid till 5th of July 2014. The person has expired. No, he's there. Right. Now he has retired or attained the age of superannuation. According to the petitioner, service ended in 2018.
Yes,
So from 14 to 18, where is the subsistence allowance? Your report is...
kindly make it record, my lord. Kindly, I will come back when another instruction.
No, this has to be in consonance with your lordship's direction, my lord. My lord, I
done in such piecemeal manner.
it is employees' money, my lord. The government has no business to withhold it. It is a kind of an unjust enrichment, my lord. Government cannot take benefit
My
from
lord,
my money.
learned senior will, my lord, doing this matter, my lord, in the point of
My prayer is, my lord.
Allow me to further, my lord.
My
instruction
prayer
with
is
learned
page 30, my lord. Your lordship has taken care of this.
Um,
Interim prayer from to 14/8/12 to 18/4.
District Inspector of Schools, Secondary Education, Purva Mednipur, signed on 27th November 2025.
তোমার senior কোথায়?
Is taken on record. Stop. Copy of the same has been handed over to the learned advocate representing the petitioner in court today. Stop. On a perusal of the report, it appears that subsistence allowance has been paid to the petitioner
My lord, তো বলেই যাচ্ছি আমি। My lord,
with effect from 1st June 2012 to 5th July 2014. The petitioner attained the age of superannuation in the year 2018.
my lord,
Stop.
me and
There is no mention.
kindly, my lord, permit to leave, my lord. Oh, the next court, my lord, matter reached, my lord.
Your matter is going on here. Nobody is there.
No, my
What is this?
no, my lord, paying apology, my apology.
Cannot be done. At least somebody should be here.
My lord, I will paying apology, my lord, please, I will interrupt paying apology.
There is no mention with regard to the unpaid subsistence allowance. Yes, the District Inspector of Schools, Secondary Education, Purva Mednipur is directed to file further report disclosing their stand with regard to the balance area payment receivable by the petitioner. The said report shall positively reach the learned advocate for the petitioner by 19th of December 2025. Stop. Release the matter for further consideration on 13th of January 2026.
Deeply obliged, my lord.
Well, kindly come to page 88 for once.
Page
88, the writ petition. There's an impugned order. The similar issue your lordship has already decided.
And for the state.
So this is a transfer matter.
Yes, whether when there are two vacancies available, this is the order. Your lordship passed this order.
Yes. Are you aware of this order?
No, not completely, my lord. I was just going
Check,
through.
check. Please check.
I have only one copy. I'm sorry. Soft copy.
You have a phone. Check up. 24806 2025.
I'm sending him. I'm sending him.
18th of November 2025.
আমার কাছে আছে তো ফোন থেকে দিয়ে দিই
Your rank is presently second in the first preferred school, third in the second preferred school, first in the third preferred school. Third preferred school, total enrollment 7,000. Please come.
ওকে ডাকতে হবে বাকিদেরকেও ডেকে ওটা
Commission was directed to revert with instruction as to whether the candidates.
I have sought for ballot still date ballot I have not received.
Nothing. 17th of November.
Yes, ballot.
Nothing.
The selection process is going on. Everybody is busy in ballot interview and verification. পাঠিয়ে দিছি দেখো না অর্ডারটা পাঠিয়েছি disposed of
The petitioner seeks transfer. Stop. The impugned order of the Commission dated 21st June 2023 mentions that her rank is presently at the second position in her first preferred school, comma, third position in the second preferred school, and first position in the third preferred school. Stop. The third preferred school has enrollment of 131 students with total 15 teachers, and no further recommendation can be generated based on the pupil teacher ratio of the school.
May I take your lordship's leave for one
Yes.
minute?
The Commission is only left with the second and the third preferred school. Now, is left with the schools where the petitioner's rank is 2 and 3. Stop paragraph. The learned advocate for the Commission was directed to revert with instruction as to whether the candidates whose name appears in the first and second position in the 2 preferred schools by the petitioner are agreeable to join on transfer. Stop. The Commission has not been able to forward the instruction as sought for. Stop. In view of the above, the Commission is directed to grant an opportunity of hearing to the petitioner and the other candidates whose name appear at the top of the petitioner in the ranking list to ascertain as to whether they are interested to join the vacancy.
This is very difficult for one ascertaining.
Right?
Because one commission has to contact them, they have to call for.
2 candidates.
Yes.
2 candidates, they are wanting transfer.
Yes.
Commission has to act. Commission cannot sit
No,
tight.
they have to be contacted, whether they are willing or not willing.
Obviously, because you have rejected saying that she is second. She is, yes, she is second or third.
Difficulty in the proposed order is, my lord, that perhaps, my lord, that was under medical transfer. No, general transfer. This is a general transfer. My lord, there is no provision in the rules that, my lord, in case the 3 vacancies opted for, if those are not available, then the petitioner or the applicant should be given the opportunity of, my lord.
All right. Suppose your submission is taken to be proper. What do? You sit tight. You find out that the vacancy is still there. You see there are number of candidates in the panel, but you don't act. You fill up the vacancy. Nothing remains.
Nothing remains. Yes.
Your action is, I will not act. Nobody can direct me to act. The law doesn't say so.
That is not. My lord, let me clarify. My lord, since the
There is no reason.
suspended, my lord, we could not proceed. The actual procedure was, my lord, my lord, rank was given.
Actual procedure, normal procedure, abnormal procedure.
When, my lord, the portal was on, my lord, the first rank candidate, he or she.
It has been
decided by the division bench. Suspension of portal is no ground to be. This cannot take the alibi today. has been settled by the division bench.
Vacancy, ঠিক আছে? If none is willing to join, comma, then the petitioner may be recommended for joining in the schools preferred
Up to this
by her. ঠিক আছে? In the event the vacancies are not available, comma, then the petitioner has to apply afresh for a fresh seeking transfer. Stop. A decision shall be taken by the commission at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. It is made clear that suspension of the Uchosri portal will not be a ground for not processing and proceeding with the application for transfer that is pending at the end of the commission. Disposed.
My lord, if I further, in case I apply, the state would be same. It will be not be considered. Your lordship has seen.
Other preferred schools will be there.
No, let them show preference to other schools to me as well. Why can't, my lord, again I have to come because your lordship has seen it will not considered by them.
Yes, next.
Item number.
For the petitioner. This is for extension of validity of recommendation in respect of upper primary selection process. This issue is covered by a division bench.
Over on behalf of Dr. Patri, engage before the division bench matter.
Where is the junior counsel?
She is assisting Dr. Patri in those
Kindly
matters.
speak just 1 minute.
In that case, please increase your panel so that others can also come. One matter is going in one court doesn't mean the other courts will not function. It cannot be done. Yes.
Just 1 minute, my lord. Kindly see the last order once.
Yes.
Passed. My lord.
Yes, say what is it?
Yes, my lord. Then, my lord, it is the second round of litigation. My lord, what happened, my lord? Petitioner was a job loser in respect of first SList. My lord, their job has terminated 9th April. Parallelly, petitioner participate in upper primary selection process. Upper primary selection process counseling was going on in the terms of division bench order in November 2024 counseling, and accordingly I participate the counseling. But at that time I was working in the 9-10 level in a separate school. Then my lord, school has been allotted to me. Appointment letter has been issued. At that time I was also working in a 9-10 level. That I chose not to join that school. Subsequently, 3rd April, my job has terminated. Then I made a prayer.
You want your
Yes, my lord.
recommendation
What
to
happened,
be
my lord? They have
extended.
as per rule, my lord, a recommendation in upper primary selection process is valid for 90 days. But in their discretion, they can extend further period of more 60 days, but 150 days it is allowed. But my lord, I made a representation before the authority within 150 days. So they can consider it. My lord, first round of litigation, honorable court directed.
All right, let Dr. Patro come.
Yes, my lord, and division bench, my lord, yesterday, my lord, one of my learned friends shows that there is a division bench judgment that job losing is a special circumstance. They should be accommodated. That is my condition. And my lord, another prayer, my lord, similar.
Let you make the submission in front of Dr.
My lord,
Patro.
a similar issue is pending before you let the heart the analogous similar issue. My lord.
Which item?
Yes, 83 to 96. My lord, your lordship.
Today's list.
Yes, today's list. 83 to 90.
And
issue by that. One matter is here.
1 minute. Similar issue, and is the other side who is here?
Dr. Patra.
Dr. Patro in all the matters.
And my lord, also monthly is 1629 to 1632. That matter I have mentioned, your lordship.
1 minute. 83 to 96 and
1629 monthly is 1629 to 1632. Similar issue.
1632.
Yes. 1629. Kindly fix that any day. I will.
1 minute. Please take down the numbers. Today's list.
Yes, 1629 to 1632. All Dr. Patru is appearing.
Let him check.
Yes, yes.
Please see. All right.
Yes.
I'll make it not today.
Yes.
Let tomorrow.
Grateful.
এই নাম্বারগুলো একটু নোট রাখুন।
I'm checking for a not today.
Item 13 not
Yes,
today.
yes, not today.
All right, not today. Item 14.
I appear. এটা সব কে ছিল আমাদের শান্তনু মিত্র is appearing on behalf of the council.
Council.
High Secondary Council.
High Secondary Council. What is the issue?
Well, I issues the uh, reassessment of the answer script. Although, my lord, there is a, I know they are all judgment against us. My lord, the
And applying for the higher secondary couple led by Mr. Shantanu Kumar.
Yes. What is your submission?
Lordship,
let me, your lordships, kindly allow me.
re-evaluation of answer script is not permitted, Lordship.
All right. I'll take it up. It's already 1:15. I'll come and take it up.
Lordship.
At 2 p.m.
Yes.
or Calcutta?
Tomorrow.
Tomorrow?
It's up to you.
No. Can it be possible for tomorrow?
Yes, I'll keep it tomorrow. Not today.
And we have affirmed an affidavit in respect of one of these matters, and maybe permitted to file it, item number 19.
Certainly, file it.
19.
Copy দেবে একটা
The copy, sir. Petitioner.
রেখে দাও কপিটা হ্যাট্রিক
Yes.
Wait, please.
Get a hard copy here.
Sir, may I come straight to the point? That is,
One minute. This is item 15 going on. It cholche na screen ta? Haan. Item 15 going on, and there are cans. You are there in the can.
Can number 1.
can number 1.
Yes.
But I'll get to the point. I take the arguments made by my learned friends appearing for the writ petitioner serially and try to give my humble answer to it. The first argument was that the rule of 225 is ultra vires and wholly void. Now, my humble submission, yes, because of arbitrary and all these things already there. But why arbitrary? What is the reason given? Why is arbitrary? Entire rule. Not in the petition, in my submission, a lot of things have been said, but no ground is really made out to say that rule 225 as a whole is bad. See paragraph 12, 9, 10, see the grounds below. This is some views have been expressed. Why it is arbitrary? Or why it is bad?
Yes.
Emphasis in course of argument, emphasis was placed on the clause in the rule giving 10 marks for teaching experience. That has been specifically assailed and grounds have been indicated that I can deal with. I have to deal it one by one. But as a whole, how can it be? That one of the learned counsel for writ petition has cited judgment of Supreme Court. When a rule can be wholly bad, and the judgment says that if the rule is altered by the parent act, then it is void. Altered by the parent act. The judgment has been cited and not by one of my learned colleagues for the writ petition, and not that judgment I have noted, and they set out the grounds of parent act. But in my humble submission, nobody has argued that this rule of 225 is ultimately the parent act. In fact, Mr. Bhattacharya has not even placed the parent act as my argument. Now see the parent act and how it is altered parent act, nobody has given reasons. That is the approach should be for parent act. Ultimate entire thing, entire whole. Now, next argument has been that this experience for teachers, giving marks for teachers. 10% mark for teaching experience. That is the point. Let us say Mr. Bhattacharya has argued that it is a malice in law. There should be pleading of malice in law. Malice has to be pleaded very carefully. A statutory provision is being said to be malice in law when it can be said. Statutory provisions. In my humble sermon, that is not the ground and said Schedule 2
experience under void appointments should not be that's I can understand argument made that experience teaching experience for gathered by those untainted candidates whose appointments were void. So therefore, the appointment void, therefore experience they have derived as a that should be also not be considered. That's the argument. Let me deal with that point, one specific point, at least I've argued. First, similar, kindly see the schedule 2. That first similar is a thing that qualification marks teaching mark is not confined to the untainted teachers who had served under their void appointment. It is not, the rule is not confined to the government schools of West Bengal. That is very important. Can you schedule 2? Schedule 2 of the rules. Schedule 2, Milord, at page 11. Start teaching experience 10 marks. See the language, Milord. Similar, I'm reading at the secondary, prior teaching experience 10 marks, at the secondary level, in a government or government aided or government sponsored school, not in West Bengal. Any government sponsored school, central, that is a central government, schools are there. If they have derived some experience from the central government school, or let's say Bihar government school, they'll all be eligible under this.
But then it's just to inform you that the commission did not treat the experience of candidates from other states, right?
No,
they had to
that
come
is the
to
point, Mr. Calcutta ascertain an application was made by the central government teachers, employees, before our division bench.
So they had to come to court to obtain an
Yes,
order, not that the commission granted it suo moto, relying on the rule.
What happened is this: the government central said we are also entitled to. Then what the division bench ordered, you make a representation to the commission. Let us see what they say. I am given to understand that the commission can correct me. Commission did not say that non-state government employees' experience is not to be counted, but they were counted out because they didn't have permanent substantive post.
That is different.
Therefore, my lord,
That is different.
I humbly submit this rule. If commission construed wrongly in my submission, is not confined to all government aided school in West Bengal. It's not confined to West Bengal. Then this argument is based on a factual assumption which is not correct. Rule does not say so. But if the commission, as my lord said, commission think otherwise, then question will arise whether commission's understanding of rule is correct or not. If the commission thought that is confined to only state of West Bengal, I say it's a wrong thought. Wrong thought. It goes against the rule. And if I may say, commission should be allowed to act to go against the rule and make up argument accordingly. So, there is no factual basis for this argument. We have to read the rule as it is. Commission is yet to argue, but commission's opinion is not binding on anybody. But I've not seen the affidavit. I do not know where they have said that is confined to only West Bengal government schools. I have no affidavit, nothing has been given. I do not say where they have. I request your lordship to read the lead
All right.
as it
all
is.
right.
Therefore, my submission is not confined to West Bengal government. In central government employees, when the commission argued, ask them what was the reaction
All right.
when
Next.
the government employees. Yes. Now, on this basis, the argument is based that only state government employees' experience will be relevant. It's not factually not correct. Rule do not say so.
All right. Next.
Yes. Therefore, let us now consider on this basis that of my submission that experience gathered by all government aided sponsored schools in a substantive post as permanent or on contractual basis. Must be substantive post.
What does this mean?
Does not they say so? Substantive post, not a temporary post. I am given to understand, my commission correct me, central government employees application or representation for getting the 10 marks were rejected on the basis that none of them held substantive posts.
What, according to you, is a substantive post?
No, which is permanent, not temporary.
So mere permanency should be there.
With a permanent appointed substantive post, must have, which is not maybe contractual, but permanent as permanent or bracket says so. Substantive post means as permanent or on contractual basis.
Right.
A permanent or contractual basis. That's the definition they have given. We have to go by the rules. The rules, unless it is declared to be ultra vires, any clause, is binding on the commission, on everybody. And even Millard, we have to say that we have to act according to rules. Therefore, what substantive post as permanent or contractual basis. Now, Millard, it was expected, Millard, the person or authority, person who assail a rule or action, statutory rules presumed to be valid. Onus is on them. Now, as my lord asked me, may I also humbly submit that nothing has been clarified in that argument what is meant by substantive post. They have not said that these untainted employees did not hold substantive post. This is why I'm emphasizing. They say the substantive experience gathered by them as a teacher was under a void appointment. Am I right? So, but this is one argument, legal argument. But the teacher did not hold substantive post. That is not the argument of anybody. So, Milord, if I can satisfy Lordship that even experience or any benefit gathered under a void contract of employment, that can be detained by the concerned employee provided he was the innocent party. He was not party to the illegality. This is under law of contract. Supreme Court specifically given, but Supreme Court has not given an illegal order, passed an illegal order. My submission would be, answer is number one answer, this question is no longer open because order of some Supreme Court in Boishagil matter is binding and final and binding. Let us see the order. Supreme Court says, see the order, my lord, the conclusion part. First part is tainted. similar Supreme Court making a classification between tainted and untainted. That classification was not made by our High Court division bench. That classification was not made. All and sundry was cancelled. But Supreme Court made this modification. And Supreme Court made a classification between tainted and untainted, two groups. And this classification as made by Supreme Court cannot be challenged. This is an order and final. And the Supreme Court has made discrimination, how do you call it, differentiation between tainted and untainted. Now let's see what tainted, they are not entitled to receive benefit of the services they have rendered. Similar, the tainted people, they had contract of employment like everybody else, and they render service as a teacher. Question is, why Supreme Court deprived them of the service they have rendered, or the benefit of service, like it said, remuneration, namely service experience, everything. Supreme Court clearly says, can now see, my lord, the last we find no valid ground or reason to interfere with the direction of the High Court that the services of tainted candidates, High Court has all candidates really, were appointed, must be terminated. And they should be required to refund any salary payments received, since their appointments were a result of fraud. This is important, my lord. Fraud to which these tainted employees are parties. This is the what is the instance of tainted candidates? They submitted blank answer papers and got appointment. They knew party to the fraud. No answer given, but they got the appointment. The 4 instances are the party to the fraud, result of fraud. This fraud is mutual fraud. Commission and the tainted candidates in conjunction has committed the fraud. In case of untainted, they are not party to this fraud. They are innocent parties, victim of circumstances. And Supreme Court making this clear distinction, result of fraud, they will not. This amount, therefore, to see no justice. Therefore, they cannot retain the remuneration even. Now, say in the case of other class, for candidate not specifically found to be tainted, the entire selection process has been rightly declared null and void. High Court declared. And High Court really didn't make a distinction. High Court, the entire process null and void, and all appointments are invalid, void. Said so. But Supreme Court now could make a modification of High Court's order. Due to aggregation, violation, and litigation, illegalities, which violates Article 14 and 16 of the Constitution. As such, appointment of these candidates are cancelled. They are being cancelled. Their appointments are cancelled. Appointments are not declared void. If appointments are void, they don't have to be cancelled. See the language, very clearly distinctive language. So the practice was found the entire process of selection process was null and void. Therefore, result is their appointment become voidable, and Supreme Court cancelling it. It clearly indicates that Supreme Court did not consider the appointments to be void, because Supreme Court is conscious of a fact that if a party is not an innocent party to a contract, is not to be punished. Principle of pari delicto. It's the law of contract. Ex turpi causa. This is law of contract. What is that? It's a contract of employment between a teacher and the commission. The contract is contained in the appointment letter. It's a contract of employment. And pursuant that contract of employment, everybody served for the period allowed, right, because of delay in the matter. But there are two groups that are different. One group is serving knowing that their appointments they have been fraudulent, party to the fraud. Other group is serving on the basis that, and if I say legitimate expectation, their state actions are honest and valid. That one mic.
Nothing to do with this case, nothing to do with this case. It is for you. Mr. Mitro argued in that 33,000 matter. In fact, all of us, Advocate General, we, just the judgment has been delivered. 33,000 teachers, their services are protected.
I'm very happy.
That's I thought.
Yeah, good day,
Mr. Mitro also appeared. I also appeared.
We all appeared. Today, আজকে এসে বলছিল order জন্য কি হয়. But I was sunset after my argument, nobody consulted me. Take it. And I'm very happy because 30,000 primary, that is primary education. Now, may I go on with this, Milord? Primary. Milord, there's a, apart from the Supreme Court order, I don't have to should not argue more. But it has been argued, that's why I have to give a reply. These were cancelled. The next line, however, the candidates who are already employed need not be asked to refund or restitute any payments made to them. Benefits under their appointment are being allowed to be retained, which cannot be done in case of fraud. It can be done only under a contract which is cancelled. But both the contracting parties are not fraudulent. There's one innocent party, and commission definitely is a party at wrong party. The employer. Definitely, no. So, Milord, this is being retained. This cannot be challenged by anybody. Final. Therefore, Milord, in my humble submission, the selection process may be null and void. But appointments, contract of appointments of employment entered into by the commission and the employee teacher is different footing. It will be voidable if discovered to be void later on. Also, side judgment necessary that two things are here. One is, Lordship knows the theory of quantum merit. I deserve as I reserve. So, if a service has been rendered, there is no allegation, there is no argument anywhere, that those untainted candidates did not teach properly. Their delegation duty. Students were not benefited by their teaching. Their performance under a contract which is being cancelled after 7 years, their performance is not below standard. This is one instance, Milord, where Supreme Court completely. However, see, their service will be terminated. Service will be terminated. Terminated, not void. It was voidable at option under order of court. A selection process declared void, but appointment made thereunder not declared void by the Supreme Court. It is cancelled by the court. It is terminated by the court. They not similar. Furthermore, no candidate can be appointed once the entire exam process results have been declared void. No candidate appointment once. Therefore, appointment cannot continue. Appointment must be terminated, must be brought to an end. Because the result has been declared void. That should be clear. Saying appointment must come to an end. And it is being brought to an end by an order of court. Not void, null and void, no void from the inception. Then but similar next thereafter, see the next paragraph. Other benefits retained by the teachers, I mean untainted teachers, are being allowed to be detained. Kindly similar paragraph 47. Sorry, clause 47. Yes, 47. Some appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with the autonomous bodies, etc.
But this paragraph will not be relevant in this case.
Please see, my lord. Just 1 minute more. Although their appointments are cancelled, these candidates who have the right to apply to the previous departments or autonomous bodies to continue in service with their entities. These applicant must, their applications must be processed by the respective government department or bodies within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of the previous appointment and the rejoining will not be considered a break in service. This is important.
No, this is not for you.
Lordship, considering order of court. Order of court. Question is whether benefit of that service made under the contract which later terminated has been allowed to be retained by untainted. And this benefit allowed to be retained. Why not experience it? Why not experience it? And this tainted people, they are being allowed to retain their experience. Their service is being continued, not a break. This is very important. The tainted employees, some of them had served previously, maybe government, other government institutions, independent bodies, etc. And they gave up that and joined this West Bengal school services. Supreme Court is very clearly saying, this is important, my lord, the period between termination of their previous appointment and the rejoining will not be considered a break. Then their seniority and other entitlements will be preserved and they will be eligible for increments. This is a sign of saying called treating null and void. Being allowed specifically. Now, here it doesn't matter whether I am appearing for any of the employee or not. I'm appearing for the untainted employees. Untainted employees. What has been Supreme Court intention is clear that untainted teachers will be allowed to retain the benefit of their period of service, including the period, their seniority, and their entitlements will be considered as if they had continued in the service of the old employer. What does it mean?
That means the old employer.
Yes. Will continue them.
Old employer, you were not in old employment. You are not at par with this.
I appreciate it. Correct. Old employers will do it.
Yes, that means
Why the old employers are allowed to do it? Why the old employer cannot say you are under void employment, I shall not give you? Void employer, I shall not give you the benefit of resumption, continuation. But it is not, I am asking for this. I am order of Supreme Court has to read as a whole. There is no question of anybody else. If you read the order as a whole, then Supreme Court is expressly allowing those untainted candidates who had given up other employments to rejoin their service. Number one, very good. And to retain the benefit of serving in the school of the West Bengal government, period of 5 years, 6 or maybe. They're allowing tainted candidates, are being allowed to retain benefits. 1 minute, 1 minute. 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 of the period of service and the government. Benefits were seniority, one of them. The seniority will remain. Although, how can it be then? Appointment is void. Appointment void, that how the seniority could be retained? Therefore, all that I'm saying, this all indicates that Supreme Court did not consider or did not hold the appointments were null and void. That's what important point I'm bringing to. If appointments are null and void for tainted, then regardless of whether the government employees came from another government institution or not, would be irrelevant. If those tainted employees who came from in the independent institutions are being expressly allowed by Supreme Court to get the benefit of the seniority
All right,
of
I
the
got it.
period of
Next,
service.
next point, please.
This is Milord. Next paragraph. Another paragraph which clearly says another thing. Paragraph 49. Disabled candidates mentioned in the previous paragraph will be allowed to participate in the first selection process if required, with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation even. Age relaxation, I'm emphasizing on this. Age relaxation will be allowed.
That has been allowed.
I'm
Yes, it has been allowed.
emphasizing on that.
Right, it has been allowed.
That's Supreme Court allowed that. What that indicates, therefore, Supreme Court says Supreme Court is paying the full weightage. Supreme Court is giving full weightage to the service rendered by the untainted candidates, to their period of service under so-called cancel appointment. I'm on the Supreme Court, weightage is being given. And then why not teaching experience? That's also an advantage. Now, argument is, therefore, the selection process was null and void. Therefore, teaching experience is also null and void. See the logical legality of this argument, logic of this argument. Is there any logic behind this? If they're null and void, then they should not get any service, employment. They should not get any salary. They should not get advantage of their seniority. They should not get any advantage to appear again. They should not get age relaxation. They should not get age relaxation. These three things cannot be given. This benefit cannot be given unless Supreme Court decided and clearly decided, intend to decide that weightage should be given to the period of service rendered by these untainted employees. And this is said very clearly by saying, retain your remuneration, retain your seniority, if you are coming from another thing, and there will be age relaxation for you for the period of 5 years, 6 years you have spent when you are appearing in real service again. This opportunity, eligibility to appear in the first selection process is not given to tainted employees. Not to tainted employees, but given only to untainted. So a clear classification is made that there's a difference between tainted and untainted employees. And this is the order. Kindly read paragraph 51 also. Accordingly, we uphold the impugned judgment, cancelling en bloc entire selection process. What is selection process is cancelled en bloc, but have made certain modifications in the direction issued by the High Court. That means selection process cancelled, but modification is made direction of High Court. Therefore, my lord, our division bench, when faced with a contempt application, they said, my order is merged in the order of Supreme Court. Therefore, to go to Supreme Court for contempt of court. Yes, this paragraph 51 modification means order of division bench of High Court merged in the order of Supreme Court. Order of division has no existence now, no independent existence now. Yeah, we have whatever see this final order. That means Lordship may refer to for any purposes, but what you like.
Refer to where?
You don't refer to this order of division, High Court order, for asserting the rights of the people, ascertaining the rights of the tainted and untainted teachers.
I didn't get it.
My lord?
I didn't get it.
No, because order of High Court has no marks in the order of Supreme Court.
Yes.
This is the only order I have to see and determine the rights. The rights. Whatever High Court has said. But that has been modified by the Supreme Court. So, my lord, I am referring to it because, my lord, I found my learned friends for petitioners or reading substantially from Justice Division Bench order of the High Court.
Yes.
Why they are reading it? I am objecting to that, saying that that is not there. It is not the Supreme Court order. Read the Supreme Court order.
Yes.
Supreme Court judgment and say whatever you want to say.
All right.
But not the reading from High Court order, which has merged.
Yes.
Has no separate existence now. That is why I pointing out to Lordship. I am answering the argument made the other side. My lord is right. That should not have been argued at all. That should not have been argued on the basis of the division judgment of the High Court.
Yes.
Yes, Lordship might have stopped them. But not allowed to argue, therefore I am giving a reply. Today I am giving a reply point by point. So, my lord, now let us come to the point. What is the then basis for the argument that teaching experience gathered by those untainted candidates during the tenure of service under the school should not be given?
Since you are referring to the Supreme Court order,
My lord, yes, my lord.
please also refer to the order of 17th April 25 passed by the Supreme
Yes,
Court.
yes. That's right.
Please come to that order also.
Division bench order, my lord.
Supreme Court's order.
Yes, I'm holding it, my lord.
17th April 25 order.
Which paragraph, my lord?
Page 108. In the writ
Oh, this
petition, I can see.
separate order, another order, no?
Yes, it's a separate order.
Separate order, I see. Then let me close this. Yeah. Yes, my lord. Right. Order dated? Order dated?
17th April.
17th April. Yes, I've got it, my lord. I've got it, my lord. We inclined to accept the prayer. This is how that's how it begins.
Yes.
We inclined to accept the prayer made in the present application, insofar as it relates to assistant teachers for classes 9, 10, 11, 12, not found to be tainted, subject to the following conditions.
That means you fall in this category?
Not?
You fall in this category?
Yes, this is found to be not tainted. Accept the prayer. Prayer, what made one application was, he prayer made curriculum. Yes, yes, that's right. And
so you fall under this category?
Yes.
You are not found to be tainted?
Yes.
Right?
Correct.
Please come to that order at after paragraph 4 in the next page.
Yes, we know. 4.
We clarify that.
We clarify that. This order we shall not be read as conferring any special right or advantage on the apostate teachers, insofar as fresh recruitment process is concerned. Correct?
What does this
Correct.
mean?
No, that's why I am not saying that this order, I am confined. I said the order of in Boishali's case had conferred some advantage and right on the untainted. I'm confined. My argument is this. I am blessed your lordship. Under the order in Boishali's case, but some advantage and rights have been conferred on the untainted candidates. And those rights have not to be interfered with. I am not asking for any further right under further orders of court. Supreme Court has lastly said the order of Boishal is final. And I am confining my argument to the rights and benefits conferred by that order, not by this order. But let's go in. Let's go into so far as concerned, no special advantage. With these rights, whatever I mean confined was conferred by the Boishali judgment.
This is in the same matter.
With all the rights and benefits have been conferred upon us by the Boishali judgment, we shall participate in the fresh selection process.
Yes.
This is the point. With whatever rights and benefits conferred upon us by the Boishali judgment, with those rights and benefits, we shall participate in a selection process. We will not divorce the rights and benefits conferred by the selection process. The argument is entirely on the basis, on the friend with my respect, that as if we shall participate in the selection process, divorce the benefits and rights conferred by Boishali judgment. It is not Supreme Court query in so far as this is the point. This is the fallacy in the argument with respect that the rights and benefits, with those rights and benefits, we shall participate in the fresh recruitment process, not divorce those rights. And one of those rights is the benefit of the service you have rendered, including everything, and which include experience and seniority and teaching experience gathered. That will be gathered. So, my lord, point is that our service as untainted teachers, the rights and benefits conferred by Supreme Court, that's why I am placing that order. They have given the right of retention of the financial benefit, giving the right of retention of financial benefit. They are giving the right of retention of the seniority benefit as and when necessary for those, as when necessary for seniority benefit. They are giving the benefit of age relaxation for those who want to participate in the fresh selection process. Similar in the fresh selection process, the freshers will come with particular age qualification. But this group, untainted, will have higher age, older age, they will be allowed to participate. Similar, this is a class by itself Supreme Court has created, and there is no classification within that classification. Well, I am only saying, kindly see, as Supreme Court has said later on in the judgment order, I find, the rights of the untainted should be preserved. Now, my lord, lordship has been shown the last but one order, order dated 23rd November, no? 26th November. Which means the Supreme Court, he said the court of first instance, let them decide. Because it is very orthodox approach by Supreme Court.
Should not have been.
Orthodox by approach.
Should have been.
I am happy.
No, this orthodox approach should not have been by the court.
No, that is not. I'm not saying that. But it was orthodox approach, Lord, because the court usually, appeal court always said that's the benefit of the first court. You will also sitting in division will say let the benefit of first court. Supreme Court saying let me have a benefit of the views of first court, who will go into the facts of the matter more deeply than appeal court would. So Supreme Court said let the first court decide, we shall benefit of it, then matter comes up, we shall enjoy that benefit. But Supreme Court did not want to deprive himself of the benefit of the wisdom of the first court. And Please see the last paragraph, last page is very important. The Supreme Court has said, I'm very happy and proud of our High Court. They have imposed so much of confidence in the High Court. The High Court shall examine the matter uninfluenced by any of the observations or merits made by this court in the orders passed after decision in Boishal Court charge. Whatever observation made on merits, etc., and Boishal Court, that High Court will not touch. But not High Court, High Court, Supreme Court is reposing so much of confidence. I'm happy. Calcutta High Court, after a long time, is gaining some importance that by any observation made by the court. That shows the degree of confidence the Supreme Court is reposing in the High Court. That I'm proud of that. The next paragraph. The High Court shall also be mindful of the fact that untainted candidates in the past selection were allowed to sit for the selection test to be held afresh, and their candidature cannot be adversely affected by application of the new rules. New rules should not be construed in a manner which would adversely affect them. This is not humbly pointing out. Supreme Court is clearly making a classification, and Supreme Court sympathies for the untainted candidates are apparent. What does this mean? That the affect and candidates cannot adversely affect the application of new rules. That is, West Bengal, the school rules is mentioned 2025. So, my lord, while construing the rule and applying it to the candidates, please ensure that the 10 untainted candidates, their rights which have been given by the Supreme Court under the order of Boishali judgment, and their selection test allowed to sit is not adversely affected by the new rule. It does not. What does it mean? It may understand it as I have understood. Even the Commission, by making new rules, cannot take away the rights and benefits which have been given to the untainted candidates by the order in the Boishali case. It is clear. If the Commission has made any rules which will adversely affect the rights and benefits given to the untainted candidates by Supreme Court in Boishali judgment, then the rule will not valid, could not adversely affect. Even the Commission making rules cannot adversely affect that right and advantage given. So, my lord, while discussing the validity, legality of the rules, kindly bear in mind this interpretation about Supreme Court. Ensure that no right given by the Supreme Court by the order of Boishali's case can be adversely affected even by the new rules. New rules has to be read in that fashion, in that manner. May I place a judgment regarding contractual fee? The innocent party is not affected by if the contract has become void.
Will it be required? I don't think it will be required. Now it is up to you what to cite and not to cite.
To be affected by termination of contract.
It is up to you. I will not stop anybody from making any submission because.
Well, I get the proposition given lordship.
Right.
I judgment cite later on.
It is up to you, sir. I won't stop you.
1968 Supreme Court that I am relying on All India Reporter, 1968 Supreme Court, 1165. at page 1176. At page 1176. এটা আমার বইটা দাও, তোমার তো পেজ মিলবে না তো, তুমি এসিজি লিখে হবে, আমার বইটা দাও, পেজ মিলবে না। Losses have been given. Well, I have read from my reported AIR. What the page bolu? 1176. 86 dicho to 86 na 68. AIR 1968 Supreme Court. 1165 at 1170. The continuation of my paragraph. 11. Sorry, Milord, delay হয়ে যাচ্ছে। বুঝবে তোমার বই ফেরত দিয়ে দিই, নিয়ে নিচ্ছ তো? বলুন তো ছিল কি, কোথায় গেল ওর লোকগুলো, কোথায় গেল? বইগুলো বাদ করে দিন। 1968 Supreme Court. Paragraph কোথায় মিলবো? একটু বইটা খুলে বাদ করে, better will not waste my lord's time. Cite this judgment later on. When will later on. বাদ করে রাখবে, paragraph number থাকে না, অন্য জিনিস। Now, my lord, may I now deal with the argument that the 10% marks given to teachers of government schools is bad. That is the main thing. I'm using expression government schools because the rule do not say West Bengal government schools. Rule do not say that. No. What are the grounds are good, and I will deal with that right now. What is the test for determining? It is said to be altered by this arbitrary Article 14. But what is test for determining the marking process? Because this is not eligibility criteria. Anybody can come. One need not have teaching experience for making application. The gate is open to all candidates, whoever. There is no restriction on that aspect. It is regarding marking of the merits, marking. And that may not be done, it is declared beforehand. The rule of the game has not been changed. That was declared beforehand. Those who apply for this post, they are expressly told that this is governed by the rules of 2025. And they know very well that those who have teaching experience of government schools will get an extra 20 marks, 10 marks, 10% mark. With knowledge of that, everybody has joined, including candidates who do not have any teaching experience, and candidates who have teaching experience. This is transparent, nothing clandestine. Now, with this knowledge, they are participating. Everybody participated. Now, what is the test for deciding? Well, I'm hard, arbitrary many times, unreasonable many times. But what test for determining this? Let me a humble submission. The test is that this marking system, what we marking, should have a reasonable nexus with the object and purpose of the rule. So lordship should have been addressed, showing what is the object and purpose of the rules. And then lordship should have been addressed that this is the object and purpose. And the 10 marks for teaching experience has no nexus with that object. With utmost respect to all my learned friends, they have not argued on this, they have not touched on this aspect. But this is the fundamental rule of declaring anything a violation of Article 14. Any condition imposed which has no reasonable nexus with the object, that is arbitrary, not anything.
Yes.
Now, my lord, in a system, lordship has seen in tender matters mainly, a lot of conditions are given that you come, but those who have financial capacity of more than 6 crores will get this additional advantage. Those who have supplied similar goods to other government companies, they will have this additional advantage. That is not eligibility criteria, but additional advantage. No court has held that to be invalid or illegal unless it was shown to the court that 6 crores financial capital has no nexus with the object of the notice. If the suppose is a contract for value of 50 lakhs and the condition imposed must have 6 lakhs, then that will be struck down, no doubt. So, case is reasonable nexus with the object. Now, what is the object of this rule? These rules framed under section 17 and 8 of the Act. Please see this Act below. Although they have not argued, I am arguing this point. তো তো argument করেনি point এরকম তুই বলেছে নেক্সাস নেই বলে argument করেছে কেউ অনিল লাইড এখন ফোন করে জানাচ্ছে অর্ডার হয়েছে না তেরি মুশকিল করছে এখন আর্গু করছি রেখে দাও থামছে ওটা বোর্ডগুলো থামে না হ্যাঁ that section 8 I'm drawing my attention to because in that rule it is mentioned exercise of powers given as 8 and 17 both 8 below section 8
Is it annexed anywhere?
of the act of the parent act
Yes, is it annexed?
Dr. Guruswami's compilation.
বলে দাও up
Remember
to
the compilation submitted on the other day by Dr. Guruswami.
কোথায় পাবে এটা ওয়েস্ট বেঙ্গল কোথায় পাবে একটু বলে তো এটা কোথেকে যাচ্ছেন এইটা তো
Is the matter in the list today?
Yes, my lord.
Which item?
Everything is running. Item number 19.
Item?
Everything is 21. Item 21.
দেখুন তো ওই স্পাইরাল বাইন্ডিং গুলো আছে না একটা স্পাইরাল বাইন্ডিং আছে ব্লু কালারের একটা স্পাইরাল বাইন্ডিং আছে Yes, please.
It's Act Miller to provide for General School Service Commission. Object of the Act Miller, I humbly submit, is to find out or select suitable persons as teachers of the government school. That is the object and purpose, to select suitable persons for government. Now kindly come to 8, Section 8. Manner and scope of selection of persons and procedure for conduct of business or commission. The manner and scope of selection of persons for appointment to the post of teachers shall be such as may be prescribed. Prescribe means by rules. The Section 2 provides the prescribe means by making of rules, not by regulation. Not by regulation. The prescribe is defined under this, as usual, Lordship knows definition. Fine, Section 2K.
Yes. Enter the.
Section.
Yes, it's at page 495 of the compilation part 1.
Yes, please.
The manner and scope of selection of persons for appointment to the post of teachers shall be such as may be prescribed. See the next paragraph. The procedure for the conduct of business or commission shall be such as may be provided for regulation. So, regulation and rules operate in different fields. This I am pointing out now because the argument was made by some of my learned friends that these rules are violative of regulations, isn't it? That's why I am pointing out, they operate different fields. And I'll come to later on. I showed you the rules provide that the regulation provides any rules will be, regulation will subservient to the rules. In case of concrete, rules will survive. That is also position. But that is argument come later on when we deal with this. Section 8 is as may prescribed. So delegated power. Then section 17. The two sections are referred to in the rules. At page 497 of that compilation. State government may, by notification, make rules for carrying out the purposes of this act. Purposes of this act. In particular, where prejudice, terms and conditions, those are things, other things. And regulation now 18 will out. Central government may, with the previous approval of state government, make regulations not inconsistent with the provisions of this act or the rules made thereunder for discharging the functions of the commission under this act. Central commission may, and makes it very clear that the rules and the regulations work in different fields and regulations are subservient to the rules. So no good argument that the regulation and the rules are inconsistent. If that is so, rules will prevail. But argument has been made elaborately, regulation, etc. Regulation, rules, new argument. Regulation ultra values the regulations. Rules are ultra values regulation. Inconvenient regulation. Their argument, I do not know whether that case is made out in writ petition, but that argument may not has to be rejected without applying in further mind. Now, this is the position. This teaching experience has it got with the suitability of the teachers, selection of teachers? That's the point. Now, firstly, giving some extra marks for teaching experience has been very usual. Is not only this commission. Various other institutions have made similar provisions. If I look take out affidavit, we have given some of them. Dr. Guruswamy also mentioned that UGC regulation rules. And we have in our affidavit.
Opposition file.
বলো
একটা affidavit in opposition file হয়েছে। এটা রাখুন আলাদা।
না কোন প্যারাগ্রাফটা আছে ওটা প্যারাগ্রাফটা দাও আগে।
Filed as Shoykot Montu. Affidavit in opposition in Can 1. The name of the party is Shoykot Montu, the added respondent.
Can 1 in this matter?
Can 1 in Lubana.
In Lubana, opposition. I don't find the opposition. Has it been recorded in any order?
What the record?
Monday.
কি বলতেছো আমি দেখি দর্শক কি বলছে শোনো।
On Monday, it was listed as item number 20, my lords.
Yes, I can see it's recorded. Can 1 opposition filed. Can 1 এর oppositionটা কোথায় আছে দেখুন তো কার সাথে গুলিয়ে গেছে। Point out from there.
বেশ দর্শক কি বলছে শোনো।
What you want to point out?
Lords, we want to point it out that it's not the West Bengal School Service Commission.
So you've annexed documents.
There are annexed documents of various other universities granting the experience.
All right. I take it. All right.
আপনি পাওয়া গেল না?
It will be found out, sir. It may have gone mixed up with some other file, but then I take that it is a usual practice.
That we have stated at page 8, paragraph Roman 8.
All right.
It has been marked as annexure D.
And the annexure B.
Not B.
No,
sir.
sorry, B no. D. At its annexures are at page.
The relevant pages.
Yes, sir. Page 60 onwards.
All right.
আর অনেকগুলো আছে এটা কি প্রথম?
প্রথমে
Firstly, Miller to a given. এটা কোথাকার এটা কাদের? Register USS.
This is University of Karnataka.
First is page 60, University of Karnataka. They have granted experience in teaching is 5 marks. They have granted. And the next instance have given the assistant professors, etc. Higher education, F2 department. Page 65 again. Page 65. The Tamil Nadu Collegiate. Education Department, Tamil Nadu. They have given this experience, teaching experience, 10 marks.
This is page 71 and page 71.
And again, another one, page 71. That is experience, teaching experience. We are giving about 3-4 universities below.
All right.
ওটা দিয়েছে, 3টে দিয়েছে। গুরুস্বামী তত দিয়েছে।
Page 49.
পেজ দাও।
No,
It's
it's
good.
not- Another example is cited at page 49 of our affidavit in opposition.
Yes.
We have given 4 instances. Dr. Guruswamy has also given,
Experience in UGC.
has given a list also, addition to that. In his compilation is higher education regulation, UGC notification, 435 at page 485. Therefore, my humble submission is, it is usual, I think unusual, for giving benefit of teaching experience for appointment of teachers in the government school. Yes. Now, Milord, it is not the case that in a appointment of, let us say, a footballer, a teaching experience is made a criteria. Then one can say no resume nexus for appointment footballers. But this is a case of experience as a teacher for being appointed as a teacher, appointed teacher. Therefore, there cannot be a dispute. It has got a reasonable nexus with the purpose of that to find out suitable teacher for this. Now, this can be subdivided in many matters. If a rule has made which has or a marking system made which has reasonable nexus with the object and purpose, then that rules, if it incidentally benefit one class of candidates, that will not amount to bad rules or bad rules. Then comes their argument that all candidates here, as if fresh applicants and those, they are as if they are all equal. I am striking a root of this argument. They are not equals. See, my lord, why I say they are not equals. Firstly, my lord, the fresh applicants are not equal because they have no teaching experience in government school. If the applicant. Number 2, we have passed selection test of 2016, which teachers with freshers have not done. They have not passed any selection test of 2016. We have taught in the government school without any blemish, and that which they do not have. So, my lord, they are not having gone through the ordeal of selection test of 2016 and having come out successfully. They cannot claim they are not equal. They are unequals. Candidates are unequals. Classification date, the fresh applications are made with the full knowledge that if they do not have teaching experience and those who have teaching experience, they will get 10%. At the time of filing of the application, for selection, they did not raise an objection to this rule, the clause of that selection. No challenge was made. Knowing fully well that this discrimination, alleged discrimination, is being made, they have, without any prejudice, without any fetter, have joined the selection process. Now, this is one, they have knowingly done it. It's nothing clandestine. Had this declaration been made, teaching marks, after admission of the applications, then thing would have been it's knowing fully well. Now, next question is that can or those candidates who had not gone through the ordeal of 2016 selection process or can those candidates who have not gone through the ordeals of 2016 selection process can be treated equally with those who have gone through the selection process and those who have been under order of Supreme Court is empowered to appear again, appear in selection process under order of court, Supreme Court. Therefore, they are not unequals. And if they are treated equally, that would have been violative of Article 14, because unequals cannot be treated as equal. We are a different class created by Supreme Court order, untainted class. We have suffered the 2016 selection process, all the remuneration. We have been given some benefit by Supreme Court and we are having express liberty given by Supreme Court. So we cannot be equated with the other applicants who had not gone through that ordeal of 2016 selection process. And had it been done, it would have been treating unequals as equals and would be violative of Article 14.
Why did you not challenge this rules and submitted that you cannot be treated equally with the freshers? You all could have come up with a challenge.
I don't have a challenge. I don't challenge. Whatever right is given Supreme Court, we want preservation. And my argument is rule is in terms thereof. Rule do not take away any of my rights or benefit given by Supreme Court. Why should I? Oh, I'm corrected. I'm told, please, I didn't know.
If you kindly come to page 9 of our affidavit in opposition, we have given a chart of the WPA numbers wherein we have opposed to the said rules, my lords. But at that point of time, all our writ petitions were dismissed. It went up to Supreme Court also. The Honorable Supreme Court also dismissed the applications, my lords. We wanted for bifurcation of the rules, my lords. 2016 process should take place separately and 2025 should.
Right. The process is scheduled.
Yes, ma'am.
We want that, but held not entitled to it. And we accepted that.
Are the orders of the court annexed?
Liquid now.
It was hard along with the Urnima's matter.
Ultimately, all the matters culminated in the 26th order, where liberty was granted to everyone. There are two sides to approach before your lordships.
But there is no challenge
Yet, because
at least there is
because
no
there is a
challenge.
difference between abilities of the councils to come very lightning speed and maybe little bit of slow. Because today it's today hard December. Just matter.
Anybody with lightning speed with the challenge of the regulation from the old set? Not aware.
My lord, In fact, they held a conference with me also. I
In
suggested.
stage of preparation.
It is in the stage.
All right.
Because the order, the SLPs which were there, some of the SLPs were with regard to grant us certain relaxations, because otherwise once you club it, what happens that we also lose.
Certainly.
We also
certainly.
lose, because we were under the impression whatever happened there would be limited to us.
Obviously.
So those are also there.
Lubhana is the old waiting candidate.
So means our prayer for being a separate selection test in regard to untainted candidates was not accepted by the court. There will be no separate selection test.
Some writ petitions are in the pipeline.
Yes.
Some are in the pipeline. You can think over.
So we did not claim any separate selection process. Court has said so. There should be one selection process. That helps.
The court never said there will be one selection process.
Court,
Because that was exactly your challenge.
court says that regard to untainted selection should be separate selection test in regard to untainted candidates of the first selection level to second. That we wanted it a mandamus declaring that. Court did not grant it.
Yes.
So there will be no everybody will be tried under the said rules of 2025.
Is it,
Everybody will be tried under the said
is it
rules.
proper? Is it proper?
It is court has said so. I cannot say improper.
No. The Supreme Court has granted liberty to file fresh petitions, and everybody who has any grievance can approach the court. So you think it over.
But this order High Court refused. Supreme Court rejected SLP. So Supreme Court approved of this. That this rule, selection process, will govern both. With eyes wide open, that a 10% mark is allotted to a teaching experience. This is important. With eyes wide open, that 10% mark will be allotted for teaching experience, a maximum 10% mark.
All right.
So this is no longer permissible for them to raise this contention. The 10% mark should not be allowed to for teaching experience.
Should not be allowed, is not permissible.
This is no longer permissible for them to argue that, because court has said same rules will govern both. Selection process, and it was then clearly stated in the rules, teaching experience 10%. That was the time for objecting for those who had said that I'm fresh application makers, that no, that should not be done. Teaching, no marks will be given for teaching experience. That was not done. They submitted application with knowledge of this teaching experience, 10% mark. But most important thing is, therefore, the conduct is this. The midstream, when the election, they have appeared in a written test also. Thereafter, they take the point that teaching experience should not be counted at all. Whether they can be permitted to urge the point. After having joined the selection process without any objection.
Yes.
In other words, can they ask for change of rule of game after they have joined the game and game has progressed? In our submission, should not be. But apart from that, we submit that is it, that this has no merit on substance, in substance. Why? They have not shown and not even argued that this teaching experience in a government school has no nexus with the selection of teachers for government schools. If the nexus is established, end of the matter. It cannot be arbitrary. Incidentally, some party may be benefited, some party may not be handicapped. As I give the instance of many things, not in the tender matters, usually 6 crores capital. You have second, maybe you have supplied similar goods to other government institutions. Therefore, those who have not supplied similar goods will not get get open, cannot. But those have been held to be valid whenever those kind of conditions had nexus with the object. If the this work involve 10 crores or more. Similar main criteria, they have not argued. There's no nexus with the object. Next, I support 10% out of 100 is not disproportionate. Is not nobody is disproportionate mark. And in fact, Milord, several candidates who are no teaching as fresh candidates, they have scored marks more than the untainted candidates in the last written tests and the so it will not, you cannot say it will not tilt the balance. It's not so had it been 50%, things like that. It's not.
There are scores of matter over here where only 1 mark is making the difference.
Yes.
Whether to participate in the interview or not. And 10 marks you say will not make a difference.
Yeah, that's 10 marks, Milord, is not the. Then there are 10 marks for academic qualification. 10 mark academic qualification. With
academic is 60. The writing test is 60.
no, academic qualification, honors will BA, MA, B.Ed, etc. Huh? Yeah?
Written examination is 60.
60.
Written examination is 60.
Let us see the schedule. Check up the schedule.
Academic is 10 and teaching experience is 10.
60 written test is the maximum. It is written test 60 marks out of 100.
Right. So we are not looking at the 100 stage now. We are looking at 60 plus 10 because here the interview list is published. And if you do not qualify, you do not go to the next stage.
That's the time. That is when come to the address your lordship. At what stage the marks will be allotted? What the purpose of interview list? To shortlist the candidates.
Right. So
Right.
the marks are added now.
Added now,
So
yes.
60 plus 10.
Even by plus 10 educational qualification, 10 marks, 70.
70.
70. And then Milord, out of 80, out of 80, 10 marks for teaching experience. It's not disproportionate. It is nobody has said it disproportionate. So reduce it to 5 marks, nobody has said that. And in another case, if 5 marks is allowed. So, but let us, I'm arguing, submitting the arguments. Arguments, they have said no reasonable nexus. That nobody has argued. Nobody argued disproportionate. Is a case that's a course made out in the writ petition. But even then, now in the affidavit said, we are given instances where fresh candidates without this teaching experience have got more marks, total more marks than untainted candidates. So but this 10% mark is not a unsurmountable hurdle. It has been crossed by many fresh candidates. That will also give me a list at page 44 of our affidavit. Of fresh candidates. Category number of fresh candidates called for interview in different subject. This is list. How many?
Total is 9488 out of
No,
20%.
similar. Page 44 also got it. Total number is 9,488. Out of 9,488 candidates, despite having no teaching experience, have been called for interview. So it has not factual support also. Arguments have been made in the petition. First of all, say why it is disproportionate, factual expression, etc. And now we are showing the fact as it actually happened. 9,488 candidates. After that, the argument disposal cannot be considered. They cannot argue. This point has not been adverted to by the learned friends. Now, please similar is not this. It has reasonable nexus. It cannot be called disproportionate or unreasonable. If 10 marks will be 5 marks, nobody's argument is that. Now, then, Miller, let us see what other grounds have taken for teaching experience, marking. See the other grounds they have taken. They have whatever argued. Yes. I have given instances of other institutions have similar mark for teaching experience. That we have given. It is not their case in the petition. That is very unusual. No other institution has allowed. No such case.
Yes, what next?
Case. Then teaching experience not mentioned in Rule 2/2016. This argument made. What follows from that? That it was. The point is because it was not mentioned in 2016 rules. Then when new rules are framed, it cannot be mentioned. Then what's the purpose of making new rules? Now, please see on this aspect the judgment they have themselves cited. This standard of this reasonableness vary from year to year. They have cited the judgment reported in AIR 1986 Supreme Court 1444, paragraph 4 they have cited.
Yes.
See that paragraph? 4. Copy it over there.
It has been cited in that compilation. Bhim Sarkar.
It has, my lords, it has been submitted by the petitioners in Bhim Sarkar and Lubana.
ওই তিনখানা যেটা ছিল
কথা বললি তো টেলিফোনে check কর।
Which one?
AIR 1986 Supreme Court
1444.
1444. Yes.
So the case has been on the Premises Tenancy Act. Those who have tenant paying rent of 400, they will be out of Tenancy Act, and others will be. This was the case. Now, Lordship knows now on the Premises Tenancy Act, there is the on the present act also. There have been. And at that time, in old time, court considered at this that this was not reasonable. Why? Please, me not. Come to Millard, page 1448, where Supreme Court is saying, relying in middle of that paragraph on left-hand column.
How does it start?
How does the paragraph start?
Oh, SCT is okay. Paragraph 4 starts, the counter affidavit does not exist.
All right, yes.
And that is long paragraph, the only paragraph they relied upon. If you turn to the paragraph and come to the where 1984, 1 SCC 222 has been referred to.
Yes.
That portion. As held by this court in the 1984 1 SCC 222, a provision which was perfectly valid at the commencement of the act could be challenged later on the ground of unconstitutionality and struck down on that basis. What was once a perfectly valid legislation may, in course of time, become discriminatory and liable to challenge on the ground of its being violated of Article 14. After referring to some of the earlier cases, Justice Venkatamaya said, the garb of constitutionality, which it may have passed earlier, has become worn out, and its unconstitutionality is now brought out to successful canon. Justice Rangam, etc., invite attention to some sentence in 74 Supreme Court. Then, what it says, then after quoting the observations, these observations were made in 1974, soon after amendment of Act of 73. They are made in different contexts and not etc. So, the test of varies. What was considered not necessary in 2016 may become necessary in 2025. A gap of 9 years. So that is because the 2016 rules, it has not make a teaching experience. It cannot be mentioned in 2025. This judgment has been followed, paragraph 4, in AIR 2005 Supreme Court, 2677, paragraph 58. The judgment of 5 judgments. Copy down, just type it. Paragraph 58 at page 2698. Itu. Itu. It's a very atokra judgment, no? Huh? It's paragraph bar kore daw. Because SCC you are giving SCC online, therefore kindly find out the paragraph 58. In Liverpool, London. And salve kotheke ei jagata. Put it. Liverpool, yes. This is also paragraph 58 of the SCC online. In Liverpool and London SP 2004 9 SCC 512, this court observed, referring to motor general traders, another, first state of Andhra Pradesh and others, 1984 1 SCC 222. This is the judgment note of seen just now. The judgment is referred to Ratan Arya and others, state of Tamil Nadu and 83 SCC, and Synthetics and Chemicals Limited and others, and 1991 SCC. This court held at page 608, paragraph 49. There cannot be any doubt whatsoever that a law which was at one point of time constitutionally may be rendered unconstitutional because of passage of time. You may note that apart from the decision cited by Mrs. Sanghi, recently a similar view has been taken by Kopila Hingadi, 2003, etc., and John Balmattan, etc. The Constitution of India is an ongoing document. It must be interpreted accordingly. In St. Francis Benjamin Statute interpretation, it is presumed that Parliament intends to the court will apply ongoing act, a construction that continuously updates its wrong wording to allow for changes. Since the act was centrally framed and updating construction, while it remains the law, it is to be treated as always speaking. This means that in its application on any date, the language of the act, though necessarily embodied in its own time, is nevertheless to be construed in accordance with the need in treat it on as a current law. Then page 70 also quoted in construing the ongoing, etc. So, what was not required in 2016 may become necessary in 2025. So therefore, in 2016, we did not make this teaching experience a mark. That doesn't mean if we make it in 2025, that teaching experience as a mark, a 10% mark, that will become invalid. We have to see, Milord. Best thing is see whether teaching experience has an intelligible different nexus with the object of finding out suitable teachers, selecting suitable teachers. That's the main object. What I did not require this teaching experience as a mark, maybe for various reasons. That's what the government can explain, or commission can explain. But will not. That has first to be pleaded. Giving the has to be pleaded. Then the state will be called upon to answer. But if it's not pleaded, no question of answer arises. Pleading is now gradually assuming more importance than it used to have in view of recent Supreme Court judgments. But I'm not on the technicality. Must be some reasons. Why it is? Because it is very, very bold argument to say 2016 it was not mentioned, therefore cannot be mentioned in 2015. This is not an argument by itself. Unless they have made no attempt to show that this teaching mark is very unusual. Nobody does it. And the teaching experience is not a reasonable nexus with the object of finding out suitable teachers in the government schools. Therefore, this argument in humble submission has no leg to stand on. Now, I've already submitted that this teaching experience is not confined to government school in West Bengal. Rule do not say so. Therefore, there is no discrimination. That only government school in West Bengal experience will be counted. Anybody, any outcome from. Then your next also can consider the rules have been prepared by expert body, NCTE. They have not prepared the rules of 2016, maybe, may not be. Therefore, they prepared this rule in NCTE. And
These rules have been prepared by NCTE, by the state.
Commission. NCTE.
The state.
Expert body. State করেছে, but they can consult with NCTE frame করেছে তো. Expert body has consulted. Anyway, if I'm wrong, is anybody for the commission correct me? Was the NCTE consulted? Correct me.
They have been taken into consideration.
Principles have been taken into consideration, including NCTE, because NCTE obliges to not recognize degrees. Minimum eligibility criteria.
Ideas have been taken, not consulted.
Not
very good. I stand corrected, Mills. I can correct it. But normally they should have argued first, and I should have been normally. So, Mills, some of NCTE ideas have been taken. That is all. Now, but then come to what is arbitrary? What is arbitrary? Well, kindly see 2002, Volume 2 Supreme Court cases, 188, paragraph 25. Paragraph 25. No. ঠিক আছে আমার বেলা ডটকে দিলেই তো হলো Paragraph 25, পাতাটা খুলে দিলেন না কেন? Paragraph 25. It has been pleaded, as noted above, that withdrawal is without any rational or relevant consideration. Withdrawal is a government, same thing. It has to be noted that this is the correct line of approach without a rational, relevant consideration. In this context, it has to be noted that the operators in state of Andhra Pradesh are required to pay the same tax as though registered in other states. Therefore, there cannot be any question of irrationality. The test of arbitrary action applicable to executive action do not necessarily apply to delegated legislation. Kindly note this. Applicable to what is applicable to executive action do not necessarily apply to delegated legislation. In order to strike down a delegated legislation as arbitrary, it has to be established that there is a manifest arbitrariness. In order to be described as arbitrary, it must be shown that it was not reasonable and manifestly arbitrary. Not reasonable. Expression arbitrary means in an unreasonable manner, as fixed or done capriciously or at pleasure, without adequate determining principle, not founded in the nature of things, non-rational, not done or acting according to reasons or judgment, depending on the will alone. In the present case, all the persons who are similarly situated, similarly affected by the change. That being so, there is no question of a discrimination took place. So, therefore, the question is, can it be said to be unreasonable and capricious without any determining principle or nexus? I am humble. None of these tests have been sought to be fulfilled in this instant case. The teaching marks 10% is wholly arbitrary, is unreasonable, or it is done capriciously without has no nexus with the object. This has not been at all sought to be proved. There are other judgments they have themselves cited, which will rely on this field, on this aspect. Other judgments also. I'll come to those judgments cited by them when deal with judgment, I will show from their judgment also. So, this simply saying arbitrary is not enough. Have to be shown. And also delegated legislation and executive action stand on different footing. Different footing.
So according to you, this rule is a delegated legislation, and as such, it cannot be held to be arbitrary because the parent act remains. This is exactly your submission.
Parent act, object, purpose.
Object and the nexus
is being
and everything.
subserved. It is not being that I'm obliged, Your Lordship. I'll put my submission as my Lord, taking a cue from my Lord's observation. I put it negatively now. It is nobody's case that allotting of 10 marks for teaching experience will prevent selection of suitable teachers. That is to be, I stand corrected. That argument has to be made and court was satisfied. That allotment of 10 marks, teaching experience will stand in the way of selection of suitable teachers. That is, should be the test of the matter. And that nobody has said so. It's standing in the way of. Then in other words, he has no nexus. It will defeat the purpose of the act or the rules, namely selection of suitable teachers.
Yes.
Next point has been taken that experience of 9 and 10 can consider for 12 and 11 and 12. That's considered. But that point, has been answered by Dr. Guruswamy very competently. He has shown the experience in secondary education. Classification is, under West Bengal law, classification is between primary, secondary, and higher. Secondary includes both 9, 10, and 11, 12. Therefore, the court cannot be asked to make a classification within class. That is the answer given to Dr. Guruswamy, which I need not repeat. I adopt that. Then next ground attack is
I just let you know that there is one writ petition filed by the 11-12 candidates that the 9-10 experience cannot be treated to be taken as experience for teaching 11 and 12. This writ petition is also there.
that is feeding that answer is
That is a petition.
that's right.
I just let you know.
Therefore, will not therefore
So
teaching
all types are
that's
here.
very good. Therefore, Millard, this argument is based on an admission that marks can be given for teaching experience.
No, the candidates are
That's the-
job losers.
Marks can be given for teaching
There
experience.
the rule is not under challenge.
And then, but while giving the marks, you find out, did you teach in 9, 10? Very good. I'll give you these 10 marks if you are a candidate for 9, 10. Marks can be given. Enough for me. Enough for me.
You and those candidates are on the same footing.
But that is enough for me. Therefore, not, if it is both as part of secondary education, 9, 10, 10, 11, then why make this classification? Why classification made by the legislature? And how can you ask the court to make a sub-classification? Court cannot differentiate between 9 and 10 and 10 and 11, 11 and 12, because they're all part of one class, secondary education. Court has a rule, our act do not say secondary education part 1, secondary education part 2. Therefore, this approach is not permissible. Is that when the legislature has made a classification and clubbed together 9, 10 and 11, 12, clubbed together to form one class, how can they ask to make it dissect it and make another class? This cannot be permissible law.
Right.
That was the argument of Mr. Guruswamy, which I adopted. Which argument means I say nothing new I'm arguing. Next ground is taken, level playing field. What is meant by level playing field? I do not know really, I'm not so much level-headed. No, level playing field. I'm trying to ascertain what is level playing field. At the time of being invited to join the selection process, all candidates were told what is the rule of this field, what is the field. If you join this game, this is your field. It will be 100 years or 200 years field or whatever maybe. You will get 10%, 10% if you are have teaching experience or government schools. If you don't have, you don't get it. So level playing field is the candidates must be made aware of the playing field and the rules. Level playing field, what does it mean? It is based on rule of law, the level playing field, that there must be certainty of the rules of game. Level playing idea is based on the rule of law. The rule of law says there must be certainty, the crux of the rule of law. That must be followed. I am humbly submitting the certainty is clearly stated in the rules. You like it or not, don't like it, don't participate. Don't participate. Or to come and challenge it immediately. But we must make the rules of the game certain. That we have made certain. Next answer to this is, that is 10 marks teaching is not an eligibility criteria. That is important. Gates are open to everybody. Had the rule been that only teaching experience persons, 5 years or so much, will be allowed to participate, then thing would have been different. Level playing field, they can know why others are not being allowed. But with all the judgments they have cited, if you find, Milord, they are all cases of eligibility criteria. Getting, not opening the gate fully, but shut the gate for some people. Eligibility criteria. When I deal with their case, I'll show that the eligibility criteria is to must not shut out, and it is level playing field apply to that, not irrelevant. Then Mirror, no judgment has been cited what is meant by level playing field, but we shall endeavor to do so. Then my next point is that the rules are contrary to regulation of 1998. And as I come to saying the rule ultra vires, rule is contrary to regulation of 1998. Kindly see the regulation of 1998. Dr. Similar heading, the regulation, the name is very, very long limb. West Bengal School Service Commission procedure for selection of persons for appointment to the posts of teachers, including headmasters, headmistresses, superintendent of senior madrasa in recognized non-government aided schools, and procedure of conduct or regulation. This is for selection of teachers or maybe for madrasa. Firstly, Milord. Now this rule has been made out under Section 18. In exercise of power conferred Section 18 of the Act, Service Commission may hereby make the previous record. That Act is quoted. Definition shall have same assigned to Original School Service Commission Act. Now, Section 18 also remembers of the Act. Section 18, please come back to me, Lord. Power to make regulation. Central Commission may, with the previous approval of state government, make regulation not inconsistent with the provisions of this Act or the rules made thereunder for discharging the functions of the Commission under this Act. Compare this Rule 17. State government by notification. No central commission is not making that rules. State government needs to make the notification, make rules carrying out purpose of this Act. Regulation is made by central commission with the approval of a state government. And the regulation cannot be inconsistent with the rules. So in case of inconsistency, if any, the rules will prevail. Regulation cannot make an rules ultra vires. Is on the reverse. Rule can make a regulation ultra vires or not. Secondly, my lord, this regulation operates in a different field, madrasa. And ours is government schools, government schools, not madrasa. So, my lord, it is not a proper argument to make that regulation is even if it is assumed to be contrary to any regulation, rules, the rules will prevail. So the argument has no leg to stand upon. Next, similar to the next point, they are arguing that they have argued rather. They have argued that actually point baki ache. No, আমাদের point. ওদের rule gelo teaching experience বলেছে level playing field, experience of 9 and 10. Let me now, my lord, start dealing with the judgment they have cited. From those judgment, how does it help them or help to support the humble submission of mind regarding proposition of law? The 2025 7 SCC 705, paragraph 39, they have cited. Mr. Vikas Bhattacharya just cited, this judgment. Okay. আমার কপিটা দাও, আমার কপিটা দাও। এটা আমার কপি।
2025 7 SCC.
2025 7 SCC 705. Yes, madam. 7. It will also be given Supreme Court cases or the SCC online.
Find out.
SCC, oh,
Just
yeah.
find out.
Your lordships may permit me, I give you a copy right now and have a copy.
No, okay,
Again,
there's a mark
party
code, no?
copies.
Court will mark it.
If it is here, then it
mark
must be here.
Lordship needs at least 4 or 5 juniors. Hand over.
Yes, 529, it's there.
আমার বিপ থেকে দাও না, এই যে আমার বিপ থেকে জামিনটা বার করে দাও, আমার দাগ দেওয়া আছে আমার।
Compilation serial number.
Yes, I've got it.
18.
529, yes.
Got it, Mr.
Yes.
Paragraph 39, Mr. Bhattacharya has relied upon this. 39. It cannot be gainsaid the factors of when, which, what, who, and how that are associated with a recruitment selection process is the prerogative of the recruiting authority and the selectors. However, this is first prerogative. However, at the same time, the process has to be conducted consistent with the statutory provisions governing the same. So, my lord, I rely on this. They cannot make selection contrary to the rules. if any, as well as principle of absolute fairness and complete. Because we'll point out here, in this case, there's no rules. Also, you find that in paragraph 40, can you go to paragraph 40? Then I'll come back to paragraph 39. In this case, there's no rules. There's a main distinction. Be that as it may, drawing from our joint experience on the bench, we can say with some degree of conviction and authority that conducting recruitment process in terms of executive orders and in the absence of statutory prescribed standards more often than not invite avoidable litigations. There are no rules were there. They now come back to paragraph 39, as well as principle of absolute fairness. Though it is true that the law does not postulate a fetter on the authority of the employer state, and it is within the domain of the government when to initiate a process of recruitment for public employment, either according to recruitment rules or even in the absence thereof. It is for the government of the day to decide in which manner it proposes to conduct selection. What would be the various stages the candidates aspiring for appointment have to pass through in order to be placed in the select list? Who would be the selectors and how weightage is to be given to each of the testing methods? A great deal of credence is lent to the process if it is fairly and transparently conducted in accordance with rules, whatever be the source, without the slightest hint of any bias or favoritism or nepotism. Full stop. So, my lord, the rules must set how weightage to be given to each of the testing methods. Weightage to be given to what? It must be disclosed. Then, normally, it is not for the courts to interfere unless the process smacks of malafide. However, the right to be considered for public employment being a fundamental right, it will be safe and prudent to have recruitment rules to govern the process of selection so that best possible talent is appointed in public service. That's the Mullah I'm saying. Suitability and best from service. Teaching experience for being appointed as a teacher. That's what that's what I'm saying. Obviously, assessing the merits of the candidates aspiring for public employment on the basis of a prescribed standard would not only provide a level playing ground field, this is for each of them, there exists excellence of any institution to which appointment is to be made would depend directly on the proficiency of its members, staff, and that would in turn depend on the quality and merit of those who offer themselves for selection and ultimately get selected, necessitating the selection to be conducted without any hidden taint or masked malafide. Last but not the least, having regard to the present times when the corruption has been held to be a work of life by certain responsible citizens of the country, very sad thing, but correct. It would have been desirable if the process of recruitment of 104 candidates was conducted after framing of recruitment rules and also prescribing the written examination to keep the process absolutely above board. It supports me, my lord. I respectfully support me because in this case, my lord, there are no rules. There are rules. And selection process was challenged. Not any rules giving any wages to anybody. Now selection process, subject matter of challenge. But what is challenge? Giving weightage to each and every testing method. Which testing method? And court says it is a government priority. Priority doesn't mean freedom to do anything. That I agree. But then it comes to be, court will start with a presumption of validity. This is law, 114E, Evidence Act also, sorry, should,
How much more time are you likely to take?
but can you tell me how much more time I should take?
It is up to
I
you.
should take. His Lordship is the best judge.
It is up to you, sir. You are nearly over
May
because
I continue tomorrow? May I continue tomorrow? Or
tomorrow I don't
or
think.
whatever date?
Maybe on Friday it will be all right, but not tomorrow.
Friday or Thursday? Not possible.
No, sir. Tomorrow I've got applications and it will not be possible.
Okay. Friday. In the first part of the morning, will it? The Friday, I've got one small matter for half an hour at 2 p.m. That's why I'm asking, Milord. I can ask the learned judge to push it off, or
Let me see.
my preference of this matter, Milord. So many persons' life is depending on this matter.
Certainly.
That's why if Thursday is not possible, then Friday, Milord, give it pretty high up. Right, sure I can finish before lunch and recess.
This matter is fairly at the top.
But depends on the other matter. Some unexpectedly, legitimate expectation sometimes is not fulfilled. Some matters takes more time. In the found that item 7 was going on for a long time. I was waiting for it. Anyway, kindly, court's convenience come first. Then I shall adjust, have to adjust.
Because you are already over, just distinguishing
That's right.
the
I have to
judgments.
deal with the judgments.
Possibly it will take much more time.
I'm only answering the argument, nothing more. I go point to point. My task has been somewhat reduced by Dr. Guru Swami. That has given. Thank you.
All right. Next is Mr. Dhor's turn. Is it your turn next?
Yes.
Mr. Dhod,
In that case,
my deficiencies will be made up by Mr. Dhod. My deficiency will be made up by Mr. Dhod.
If there is any. Hello, that would be one line order, identical order. In there is a little separate applications, even better candidates who got the benefit of they had an earlier job. Now, because of these confusions, many of them, the headmasters are saying that let the court decide, thereafter we would allow you to join. So these are the circles. So they made an application. So kindly I just
let the court decide. The Supreme Court has decided already.
Supreme Court has decided for
reverting them.
No, question is whether many of them, there are total 8 counselings. Now, majority of those counselings, in fact, tainteds were mostly in the first counselings, which was, but that's nothing to do with. Now, majority of them are from first counselling to 7th counselling.
All right.
Now, if Lordship holds that those who are appointed after second counselling, because first and second were within time, third, fourth, fifth, sixth, seventh, those were
That has not been argued also.
that I will argue that why I say that the Supreme Court has 100% clarified that who are tainted and who are not tainted.
That is different. I'll come to that.
That matter is coming on 10th, I suppose. The matter regarding expiry panel candidates, it is coming on 10th before your lordship.
No, expiry panel.
That sir, you can leave.
I can go.
Yes, I'll keep it on Friday.
Friday, in the first half.
And at a higher position in the list so that you can make your submission. And in case it doesn't take up, then it is an understanding during recess. I'll take it up so that you can be relieved in the second half.
Yes, but second, that will be take half an hour maximum. But some court has a practice of hearing matter for short while, in a piecemeal manner, for the benefit of the lawyers and to the detriment of litigant.
In this matter, I
may take my last leave.
Yes.
I'm seeking kind leave to correct the fact sheet of the affidavit in opposition.
আমার বিটটা কোথায় গেল?
You have mentioned the wrong number.
No, no, no. The name has been
Wrongly.
fact sheet. The fact sheet.
What is the name that you have mentioned?
HON'BLE is the name. The applicant who has been added as a party.
Yes.
The fact sheet, it has been wrongly typed as Shipra Mai.
দেখুন তো এটা খুঁজে পান কিনা?
Yes, but it's been added up to your lordship, madam.
Today?
Yes.
তাহলে দে ওপরেই আছে।
Due to the learned advocate general is in the
এনাকে ফেরত দিয়ে দিন। এইটা এনাকে ফেরত দিন। মিস্টার ধরকে এটা ফেরত দিন।
learned advocate general is in the
Oh, 1 minute.
PC.
1 minute. This was not required. Mr. Mitros Jr. will please take this back. This was not required. Yes. The AG want to submit something?
May I mention, because I mentioned, because item number 13, my lord will remember that where matter will be, my lord, whether it's sat or
the tribunal matter, my lord, your lordship was pleased to release the matter initially on my submission that it ought to go before the tribunal. My learned friend's contention was there is no judicial member in the tribunal. My submission was that one must file a petition before the tribunal and then come to the High Court. My lord was pleased to prima facie agree with me and pass an order. Thereafter, I think the matter was mentioned once again, and today, my lord, it's appearing in the list.
Learned AG, 1 minute. May I finish with this and then hear that?
Right.
that will be beneficial for, because otherwise, my lord, it will be jumped. I will cite
Right. So please wait, let me pass an order in this matter.
item number 13, it may be.
Item 15.
That is jurisdictional issue, alternate.
But submission made on behalf of the applicant in Can 1 of 2025. Yes, sir. As the recruitment rule pursuant to which the ongoing recruitment process is taking place under challenge, and the parties are at the stage of advancing arguments, the commission is directed to publish a public notice. Commission, please, are you here?
Yes. My lord, we are here.
Oh, yes, you are turning that side. I missed.
In which matter? In 515.
The commission is directed to publish a public notice disclosing pendency of the writ petition, clearly indicating that the fate of the recruitment process shall abide by the result of the writ petition. Stop. The said notice is required to be published so that none can claim any right or equity even after the conclusion of the selection process. Stop. After the selection process, no, not even after. If the selection process concludes prior to passing a final judgment in the instant matter. List for further hearing, 5th.
Any outer limit for publication?
Do it immediately. Why I say? So that
we are not in any difficulty.
None is in any difficulty.
Right.
That's it.
Otherwise, see, we are in the midst of a hearing.
And only one submission, my lord. It is understood that, my lord, all these, my learned friends are going to make submissions on Friday in item number 15.
Not know, but
some of them. So, my lord, my senior, Mr. Bandopadhyay, is in difficulty on Friday. My lord, whatever, my lord, happens.
On the next day. Yes. I'll hear.
But I'll be addressing, my lord, after. Kindly permit me to address after Mr. Dhar, or before Mr. Dhar, whichever your lordship feels would.
No, there was an understanding that lordship that
you on the first day,
because you are a neutral.
You wanted to argue after all these applicants. And
Right. Very good.
Applicants, my lord, I don't think Friday will be complete. Mr. Sannal is there.
It will certainly not be complete, and that is the reason this today's publication order is being passed. Because Supreme Court has set a deadline. the commission will be bound to follow that. Now, Supreme Court has also passed on a very onerous task on the court to hear all these matters and decide. And within 1 month, it is absolutely impossible. Not even 1 month, 3 weeks prior to the vacation. It is
Have only
impossible.
18, 19 working days.
So it's absolutely impossible. So many candidates to be heard. It will certainly take time.
Not even 18, 14 working days.
So whatever, let it be made public that this matter is going on. None can claim any equity, and nobody will at least feel that no, I didn't know that the matter was there. Let there be a public notice.
Yes.
And then whatever happens, happens.
But it will be.
Yes, now the Advocate General, we are over with 15.
In Bhim Sarkar, your lordship is not passing anything.
Order will cover.
No, he wanted to come up with that application CAN 7 or something.
Wait, I am hearing Mr. AG in some other matter. Just wait, I'm not rising, sir. You all hardly leave me at 1:15 and at 4:30. Hardly. Yes, AG.
But I think Mr. Shamim wants to say something. I am okay with the matter being fixed on any day, Milord, as per the convenience of the court.
Yes. I am.
It's absolutely inconvenient.
So next week, or because that matter is going on, and another thing is that, my lord, because it's fallen from my lord, this court, my lord, there is public notice regarding other matter, my lord. They make this public notice in 2 newspapers. One is that in English and
Published in the official
website
of the
yes, as my lord deemed fit.
যেখানে বললাম না published in the official
Oh,
website
yes,
of the
madam,
commission.
Yes.
That is the most transparent way.
More transparent.
But then item 13, no date fixing.
Yes, my lord. Then my lord.
Item 15 you want?
For
correction of back sheet.
My lord, item number 13, then.
Oppositionটা কি পাওয়া গেছে?
Then item number 13 may be posted in next week. Item number 13 may be posted in next week. Next week or?
Let it remain.
Oh, yes, my lord.
As and when it appears, we can pass necessary orders, because changing the position of the list will be difficult.
Should I keep the opposition with me? Because I was thinking the difficulty in finding out. Now I have served to the other side, so that's why I was saying to my learned friend, it would be better that instead of, because burden we can clearly understand. So it's served on, I will give, that would be better. The oppositions are there.
Yes.
Affirmed, also served to the respective parties.
Yes. As and when matter comes up, you.
That's item. Yes. So that it can.
I'm not passing order.
Yes.
In matter. It's only in this matter, item 15, that the order is being
Yes.
passed. Backsheet power.
I say that nothing in item number 21. Kindly pass one line order. Add can number 7. Do not hear me today. Once I finish for everyone, thereafter there is a little small group who stand even higher footing. So today's I am praying, kindly allow the can.
Allow. But I am not allowing. Is the can there in the list?
It is in the list. It is in the list.
Let it take it that it will be.
I understand.
Be prepared.
Correct.
Passing any.
I understand.
Any order passed.
The file will go. Yes.
Signing, checking.
Ma'am, I do understand.
There.
Once I finish all.
In can দেখে নেবেন of 2025, correct, B, back sheet of the affidavit in opposition filed in court today. আজকে কি একটাই opposition file হয়েছে না আর কিছু file হয়েছে?
We have filed in Shishi. Item number কত শিশিরটা? 19.
আমার কাছেও আছে তো।
I'll file it today. Please take it.
It is already taken on record. We have kept it with the record.
In fact, I also have affirm served, but I have not given because it is better I keep it. Otherwise, my lord, it will be difficult for the officers. Yes, yes.
As and when matter comes up,
Then we'll give.
And your lordship
Yes.
has to allow.
please do.
Hey.
Otherwise, it will not be recorded. It will
I
be
understand.
Very
I
good.
understand.
Yes, yes.
Why is he, what is your name? Why is your name not reflected in the order sheet? I do not see his name in the order sheet. I do not know the reason why. You put in the slips adding names of persons who are not there in court.
Just remember this, when you will become old like us, you will
Mr.
carry.
Dhod is not old, Milord. I
No,
beg
no.
to differ.
I'm much older. I say that.
Taking the example
No, no.
for himself.
I'm saying.
No.
I say.
Let me turn this
No,
off,
no,
Milord. I'll see.
I say that when we'll Milord become very senior one, you will cherish this moment. You'll understand the human part of the justice delivery.
Great.